In respect of item number 1, Your Lordship are making an unusual prayer. Mr. Mishra is engaged in this matter. He will not like to appear before this bench, actually. Because Justice Ette and we all started practice from Mr. Mishra's chamber.
Bench of which Honorable Justice Ette is not a member.
Obliged, Lordship. Obliged.
May I please, Lordship? May I please, Lordship? Lordship, I beg to mention item number 2 of today's daily list, Lordship.
What happened?
Lordship, here we will file an affidavit, Lordship. Lordship may kindly allow 4 weeks time to file affidavit.
You're for the Union of India
Yes, Lordship.
or for the appellants?
For respondent side, Lordship.
All right.
Respondent number 3 to
For the
55.
private respondents, all right.
Yes, yes.
When counsel, your good name, madam?
Armedhi.
Harmedi. Appearing for the private respondents, comma, praise foreign is granted 4 weeks time to file an affidavit on their behalf. List affidavit in opposition, list up 4 weeks.
Obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 17 of the part 2 hearing list. Your Honor, I am recently engaged in this matter. So I would be filing my wakalatnama by the end of
Do it. Who's stopping you? You don't need to mention for that, no?
May it please your Lordship. Lordship, I pray for listing of a writ appeal, Your Lordship. The matter is otherwise listed on 17, Lordship. We have some inconvenience on the day, Lordship. So,
17th is already listed.
Lordship,
Then what is the problem?
I want it preponed, Your Lordship.
Why?
Lordship, there's some inconvenience on our part on that day, Your Lordship. There's some inconvenience on our part, Your Lordship.
No, that can't be a ground.
Lordship.
No,
Lordship.
sorry.
Lordship, I pray for listing of a writ petition, Lordship, day after tomorrow, Lordship.
What is the matter about?
Lordship, we are challenging some provisions of the Wildlife Protection Act, Lordship, which provides for ownership title of those captive animals, Lordship, without any proper verification.
Okay, day after tomorrow.
Lordship, obliged.
Daily list for orders item 9.
Yes, my lord. The interim applications 2573 and 2587 are for impediment as respondent interveners, my lord. We want to file affidavit and challenging the writ petition.
You want to oppose their impleachment?
Yes,
IA number so and so have been preferred by certain applicants seeking impleachment in this PIL, and counsel for the petitioner submits that he is opposed, that he desires to file. Yes.
Lordship, I am the counsel for the petitioner, Your Lordship. He is for the, he has filed the IA, Your Lordship.
You have filed the IA.
They have filed the IA.
Okay.
And what we had said earlier also, Your Lordship, we are not looking at this matter from the prism of religion, Your Lordship. This is pertaining to.
Now, if you have any grievance, you file your own petitions. We don't permit your impleachment.
Lordship had observed the
Already we said that yesterday, last
on
night.
the last
my
occasion.
lord, we do not seek any other relief. Only we want to oppose.
If you
the-
want to prosecute some other relief, some relief in this court,
No, my lord.
independent of this petition, you are free to do so.
Not in, we were parties before the Cross-Seas Commission. And we submitted affidavit opposing the release claimed in the writ petition.
Yes.
Now also we want to oppose because it is
What is the relief? Let's see.
reservation, there short reservation, 80% reservation for the local. It is totally unconstitutional according to us.
All right, we'll permit them to intervene.
I leave it to you, Lordship.
My lord, the objection raised by the writ petitioner is also an objection from the government also. My lord.
Okay. You want reservation? 80%?
My lord,
No,
my lord,
objection raised by the intervener. Yes, right. IA number so and so has been moved by such and such. Title लिख दीजिएगा. Seeking impleachment in this PIL after hearing the arguments advanced by learned counsel, representing the parties as well as the learned counsel, representing the applicants seeking implement, we feel inclined to permit the applicants to intervene, act as interveners in this PIL list for admission after 4 weeks.
Lordship, in regard to the PIL, your lordship, the state was supposed to.
In the meantime, the
update.
state authorities, respondent state authorities may file their affidavit.
Obliged.
Item number 10.
Wait, please, your lordship, in IA, we want to file reply, lordship.
What is the IA?
IA for stay of the judgment and order dated passed by the learned.
You are for the respondents,
I'm for the appellant, lordship.
appellant.
In this case, what has happened, lordship, the municipal, the executive officer is transferred, lordship. New executive officer has joined, lordship. Therefore, we seek some more time, lordship,
So the IA has been filed by whom?
by the appellant, lordship, as applicant.
Appellant means the private party, Khandan Kumar,
No, lordship,
municipal board.
business side municipal board, lordship.
I'm for the private respondent.
So you have filed the IA.
They filed my lord.
We have filed the
IA is for seeking stay on the impugned judgment.
lordship.
Okay, so what do you want today?
Lordship, they have, in the IA, they have filed their reply, lordship.
Hmm.
Affidavit in opposition, lordship. With regard to the affidavit opposition, we want to file the reply. But the executive officer is transferred, lordship. New has joined.
So how does it matter? This is not a contempt. Is it a contempt?
No, lordship.
Then
We have sent the copy of the reply to them along with a letter, lordship. That has not come to us, lordship. So that they seek more time to.
He wants to file a reply to the affidavit in opposition filed by us, my lord.
so what does the executive officer have to do with it?
This appeal has been filed by the executive officer, lordship, on behalf of the Business Side Municipal Board, lordship.
Okay. So but then he is in an official capacity.
Lordship.
So whosoever the executive officer is, he is representing the board.
No. Lordship. The executive officer is representing the board, lordship.
Yes.
New executive officer has joined recently, lordship.
The board is represented by a council here or not?
Lordship.
He's there.
No, my lord, I am for the respondent.
You are for the respondent. You are for the board.
He is for the.
So you say that the affidavit could not be signed. That's what your case is.
Lord-
All right. And counsel representing the appellant submits that affidavit in reply to be filed on behalf of the board could not be signed because the officer in charge, that is the executive officer, has been transferred in the meantime. He prays for and is granted 6 weeks time to file the affidavit in reply.
Oblige, your lord.
Item number 11.
Yes, please.
Lordship, kindly this matter may pass off for the time being, lordship, timing after some time. Oblige, lordship.
Item number 12 and 13.
Why you should pass an order? It's his choice. Come on now. That's a different. There's no need to refuse because. It's one senior. It's not always exactly what we thought we were talking about. That cannot be a reason for your. We'll have to change that. We'll have to that meeting again. Yes. Yes.
Item 12 is still await the judgment of this petition filed by the DPI.
Lordship, in respect of item number 13, my lord, this is wrongly listed, my lord. It should be listed along with my lord, PI 43 of the 23, my lord. There is an order, my lord, already in the PI 23 of the 24.
PIL 43, 445. Okay, what has happened to that PIL? Why is it not been listed? Find out. What is the issue involved in this PIL?
In my side, regarding the implementation of the recognition of the implementation 2000 section.
In the similar case, lordship, in the Delhi public school, the lordship judgment is awaited.
Judgment is awaited. All right.
Same case.
The matter is deferred by 6 weeks.
Yes.
As judgment has been reserved in a bunch of writ petitions involving similar controversy.
Yes, obliged.
वो DPS वाला number डाल देना.
Item number 13 matlab should be come up in PIL 43. Along with PIL 43 oblique 20.
Segregate will be required.
It should, there's a wrong mention about this.
Yes, madam. It should be
The
43.
writ petition number 445 में लिखेगा. This writ petition has been wrongly tagged with PIL number 48/23, and counsel for the petitioner states that the matter involving analogous controversy is PIL number 43/23.
My lord.
What is the name, title?
Title, my lord. Inamul Hussain and 3 others.
So Inamul Hussain and 3 other sources.
Deeply obliged.
Item number 14 and 15.
Yes, please.
Lordship, in item number 14, notice has been served to paper publication.
Two,
According,
you were to file application for substituted service. Have you filed it?
yes, Lordship.
When? When did you file it, gentlemen?
We file IA and accordingly, your Lordship,
The order has already been passed.
yes,
All
allowed
right.
for paper publication.
Where is the, where is the publication? Has the publication been done?
Yes, affidavit is also filed.
This is not the IA, this is for stay. What is the number of the IA, do you know?
Two zero six four of 23. Yeah. Oh.
Yes, the publication is here. This is the newspaper, yes. Achha, they have filed an affidavit in proof of service. Notices for effecting service on the respondents numbers 1 to 177 have been published in the Aizawl Post newspaper dated 30th August 23. You are supposed to make a publication in 2 newspapers. This is only one.
No, there are 2 newspapers.
You have not filed the original along with the affidavit.
Original is also filed. Lordship.
No, this is only a photocopy of Aizawl Post only.
No, copy of origin newspaper is also enclosed.
Mizo Delhi, Banglaini,
Bangla.
that is it.
Yes, Lord.
Despite service of notice, comma, no one has, despite publication of notices, comma, no one has put in appearance on behalf of the private respondents. This is a land acquisition matter.
Yes.
All right, list the writ petition for admission after 1 week, 2 weeks. Who's there for, you are for the respondents number 1 and 2, 1 to 5.
Yes.
Already there, you are there?
I'm there.
So, Mr. Nair?
This is the other matter. Number 15, my lord, or respondents 1 and 2.
Okay. 15 service has been effected?
Fine.
All right. So the interest of respondents number 1 and 3 is common to those private respondents.
My lord, I have not seen the.
Give a copy of your this writ appeal.
Lord.
The order must be the same, Mr. Nair. Writ appeal number 265. Give a copy to Mr. Nair. List for admission. What about service in item number 15? Then over here.
15, my lord, only two private respondents I'm using, my lord.
All right.
The rest are official.
Official. So in 16, you can mention that service, Mr. P.D. Nair puts in appearance on behalf of the respondents numbers 1, 2, and 3. 1 and 2. The other three official respondents are duly represented by Mr. Kalita. The service is complete. List for admission along with students after 2 weeks.
Item number 16.
May it please your lordship.
Yes, please.
My lord, here we have filed a review application, my lord. My lord, here before that, my lord, there is
In review of which order?
My lord,
What is the order under review?
yes. Review. My lord, order is at page 20.
Yes. So this order under review has been based on another judgment
Yes.
passed in writ appeal number 87 of
Yes,
20.
yes, my
Have you moved any review in that?
My lord, actually, we have approached the Honorable Supreme Court, my lord. Thereafter. Then, my lord, at length matter was heard, and my lord, the basic issue in this.
What has happened in Supreme Court?
Supreme Court has, my lord, allowed us to move a review before the court below.
So
This honorable court, my lord.
it's not a court below, gentlemen. But you have to seek a review of the judgment in 87-23. We have based our judgment on that 87-23.
Yes.
So how can we go beyond that?
My lord, actually 47.
47.
Writ appeal 47 is before your lordship.
Yes.
My lord, it was decided on the line of 87.
Yes.
But my lord, issues in 87 and 47 are different, my lord.
Okay.
47, we have raised the additional issue, my lord. We have challenged the basic policy, my lord. Of 2017, that was the catering policy. Only on the ground, my lord, of livelihood. Basically, we are hammering on the
This is a
ground.
withdrawal. The Supreme Court has said nothing. You withdrew it because you were losing out. That is the apparent reflection from the order.
My lord,
The
I have.
SLP was being dismissed. So you took that chance. All right, sir, we'll go and file a review.
My lord, I humbly submit, my lord.
Yes.
When these issues were raised, my lord.
Yes.
Honorable apex courts queried, my lord.
The only review has been permitted only on right of renewal.
Yes.
That's
yes,
it.
Yes,
So
my lord.
policy, etc., there is nothing
My lord,
in that order.
Policy matter is of that renewal part, my lord. Because the new policy do not have a that renewal, my lord. Earlier policy had a renewal, my lord. On that basis, apex court passed the judgment, my lord, that a minor units will be allowed their licenses. My lord, 2016 was the judgment.
Yes,
Subsequently,
Mr. Gupta, what do you say today?
Today,
My lord, there's a
there is an IA, my lord, today.
for
For
condonation.
condonation.
That's what we are asking.
My lord,
What do you say on
we
that?
file objection to.
If you want to file objection,
No.
all right. And counsel, though stricto sensu review, there is no concept of limitation.
Yes, my lord.
Then
That is.
what is
they
with
have filed, my lord, because-
that's what
For
we are
above
saying.
portion, my lord.
There is no concept of limitation. You argue on merits.
Yes, my lord.
My lord, we fix,
We will consider the objections in the review.
my lord.
All right,
Ma-
condonation allowed. In view of the fact that the petitioners approached the Honorable Supreme Court by filing writ, especially to appeal number 12339/23, which has been disposed of by order dated 5/7/23, leaving the petitioners at liberty to file a review petition, in respect of their rights of renewal, and as the connected review application is delayed by 100 and so days, we deem it fit to consider the review petition on merits rather than ousting the applicant on delay. Thus, the application seeking condonation of delay is allowed. The connected review petition will be listed for orders after 1 week.
My lord. Deeply obliged.
Item number 17.
Yes.
May I please relax?
Mm.
Well, this writ appeal have been prepared against the order dated 26/2022,
Mm.
passed in WPC number 58 of
Mm.
5843 of 2010.
Yes,
my lord.
please.
Well, before going to the impugn order,
Mm.
the facts of the case in nutshell is that he was appointed in the year 2004, my lord. He was granted paternity leave with effect from 29/11/2008 to 13/12/2008, 15 days, my lord.
Yes.
Thereafter, he was overstayed
Offered
without informing the authority.
overstayed. Okay.
My lord, ultimately,
Mm.
several communication was made to the
Mm.
petitioner
Mm.
and the respondent here of my lord to uh, uh, report it back to the court.
Mm.
But afterward, the court of inquiry declared him deserter.
Yes.
And accordingly, my lord, thereafter, after 7 months, he sent a telegram
Mm.
to the authority that he was suffering from tuberculosis and his mother was expired. And therefore, in
Oh,
the
gentlemen, come to para 7 of the impugn order.
my lord,
Forget about the facts. Come to para 7.
Para?
7 of the impugn order. You have admitted that you did not supply the memorandum of association, memorandum and article of charges.
But they stated that no memorandum of association received by the sent by the authority to the petitioner. This is the dispute, my lord.
You did not deny. You are for the authorities. Huh?
Yeah.
So you did
No,
not
my
deny.
lord, I am for the respondents, my lord. I am for the response thereof, my lord, in the petition.
You
And
are for
appellant
the,
hereof.
you are for the Union of India.
Yes.
So it is your admitted case in your affidavit. You admitted that we did not supply because he did not never ask for it. He's not supposed to ask.
My lord, the official records were called for by the, during this dispute that the signature appeared on the ID card. Is refused to accept that
Writ
the
petitions,
signature appeared in the ID card.
gentlemen,
It
writ
is not-
petitions are decided on affidavits and pleadings, right? Read the pleading at para number 13 of the writ petition, which is reproduced in para 7 of the impugn order.
Yes, my lord, but it is inadvertently, what? But here, my lord, he was selling the dispute, dismissal order at my lord, page 123, my lord.
Yes.
Page 123. After perusal of the records, my lord.
The honorable single judge holds that the signature on the ID card is not similar. So that's a finding recorded by a single judge of this court.
That,
On fact, why are we supposed to intervene in that?
my lord, that
And in face of the fact that in your pleadings, you admit that yes, we did not supply because he never asked for it. What more is required then? What more is required, gentlemen? Tell us, please.
my lord,
Is the court not competent to compare the
my
signature?
lord, observation of the court or
Yes.
the honorable single judge.
Yes.
is That in order dated
Para 13,
26/4/2020.
para 13. Yes,
Relevant page 125, my.
yes.
Accordingly, respondents in Union of India had Union of India to hand over the original of the Annexa B, page 9, acknowledgement due to the court master for placing it before the registry to do the needful to get it verified by the appropriate handwriting expert. In doing so, the registry is to provide the specimen signature of the petitioner appearing in the Mukalatnama as well as affidavit and close.
We are not supposed to, this was wrong order. We are not supposed to act as investigators in the writ petitions. We looked at your pleadings. You don't deny. Why are we supposed to go beyond? He had taken this ground in the appeal also. Specific ground. How did you deal with that?
My ground is that, my lord,
How did your appellate authority deal with that submission? Tell us.
my lord, similar dispute was arising in other case, my lord. This honorable could,
We have put you a question, Mr. Counsel.
this honorable.
We have put you a question. How did your appellate authority deal with this objection raised in the memo of appeal? Tell us.
Pardon, my lord.
How did the appellate authority deal with this argument raised on behalf of the appellant in the departmental appeal? This objection was raised. It's a fact. Come to this judgment.
Judgment at
Yes, single bench.
page,
Yes.
11 page at 27, 127. my lord.
Yes.
Ten para, 10.
There are 7.
A reading of the stand of the.
All right, before that, let us see his memo of appeal. Ms. Chaudhary, you have got the memo of appeal?
They have not annexed it against me.
You must be having, it is there.
Yes.
It's very much there. Don't say, make such a loose statement. Page 82. Let us see whether this ground has been taken or not.
Ground, my
Yes.
lord, that
Yes, ma'am. I'm sorry, madam.
18, my lord. Page 18,
Again, your briefing counsel is to blame. No?
18, my lord, page.
Page 82.
18.
Read this.
One, my lord. For that while deciding the issue as to whether respondent have duly followed the mandatory requirement providing under Rule 27C01
He is not
of the
getting whatever
CFA
we
Rule
are saying.
1955 at the
Mi-
time of initiating.
Mr. Counsel, what is his good name? You please hold on. Yes, Ms. Chaudhary, where is this ground?
Yes, my lord.
Yes, para 7.
Roman 7.
Yes. No ground in the appeal, Ms. Chaudhary, that this memorandum and,
Page 87, my lord.
yes, read please.
For that the disciplinary authority and the inquiry officer miserably failed to consider the two telegraphic messages sent by him narrating the actual problem for not joining his service and thereby prayed for extension of
Ms.
leave.
Chaudhary, not that. The interference has been made solely on the ground that the article and the memorandum of charges were not served.
Records were produced. From the records,
That was never a ground before the appellate authority, please. Why should we allow you to take this ground in the red court?
no, I'll just place it, my lord.
Yes, read the detailed memo of appeal. And you've taken all other grounds. No chance of cross-examining the witnesses. Yes, it is there.
Yes, paper, Roman 5, my lord.
Roman 5, yes.
Yes. The
How did
inquiry
your
officer
authority
as
deal?
well as the discipline authority did not serve the relevant documents relying upon preparing the article of
Yes,
charges
yes,
against
yes.
the appellant and as such. the-
No, Mr. Chaudhary, this is a couched language. Documents relying on preparing the article of charge.
They are, my lord, they are only
Yes.
constable, my lord. My lord, fact of the matter is this
No,
show cause notice was never.
This
served.
appeal merits admission, sir. Admit issue notice. Mr. Chaudhary puts in appearance on behalf of the respondent. Heard on prayer for stay. The learned single judge interfered in the order of penalty.
My lord,
of-
can I make one submission?
Yes, please.
Now, learned single judge has basically interfered with the order of punishment because, my lord, show cause notice were not served.
Articles of charges,
Article,
not show cause notice.
it's a mandate under Rule 27. If a lordship will kindly.
So
come to
now
place-
this finding of fact runs contrary to your pleadings in the appeal.
No, my lord. End of the day, my lord, in a 226 proceeding, unlike in a civil suit, my lord. I
That
think-
is how the learned single judge has proceeded
No, if a lordship.
in your
will
writ
come-
petition.
Please come to my lord, page 132.
Yes.
And you see what is the reason why single judges interfered, my lord. Para 14.
Yes.
Rule 27C1 of the CRPF Rule 1955 inter alia provides for the procedure for conducting a disciplinary inquiry against the member of the force. Rule 27C1 provides
Mr. Counsel, where were you reading that part where the learned single judge has referred the matter to the handwriting expert? Where is that order?
that is at page 125.
125, my
So
lord.
thereafter, what was the reason that the learned single judge
My lord,
deviates from that very direction?
No, my lord. No, my lord. In fact,
Yes.
the report says that these are not similar.
Which
That
is the
what-
report?
No, report is before the record of the learned single judge.
Let's see.
Yes.
All right.
It is in the record of. the
If
learned
there was a
single judge.
report, Ms. Chaudhary,
Yes.
there was no reason for the single judge to have indulged in this exercise.
Because we filed a reply, in the
Hmm.
reply, they took a stand that no notice was served. Then somebody else's signature they relied upon. It was in that circumstance. My lord, the
That-
single judge
And
failed.
that becomes a disputed question of fact, and the red court should not have interfered then. We'll examine the matter requires
Admission is all right, my lord. This stay will create problem, my
No,
lord.
no, we will not permit
Learned
this.
single judge has not let me off. Learned
We
single
know.
judge says you start the proceedings from that
That means
stage.
the order of punishment goes.
Yes.
Consequence is no, we are not satisfied, sir.
No, my lord, if rule 27 is violated,
We'll-
is the learned single judge is to keep mark, assuming in a given case, my lord.
We'll
there is-
we'll record appropriate reasons
Yes.
then. Yes,
Supposing in
That-
an appropriate case, my lord, a particular point is not urged. And during the course of the hearing, the matter comes to the notice of the court.
Okay.
Is the court supposed to ignore that?
very well, all right. Heard on application prayer for stay. Land counsel for the appellant urges that the appellant never raised a ground in his departmental appeal that the memorandum and articles of charges were not served on him. This new ground was taken in the writ petition. In support of this contention, he has drawn the court's attention to the pleadings in the departmental appeal of the appellant, wherein, at para number paras numbers 6,
Five, not so.
5 and 6, wherein, no, not 5, para 5, 6,
The end.
para 6. Para,
Towards the end of para 5.
it's there. That's a specific ground here at para 5. Where is the appellate authority's order? Let's see.
Yes.
Is there a forwarding letter for the memorandum and article of charges?
My lord, in the records from the records, what transpired was, it was received by somebody else, not by the petitioner. That is what the learned single judge has said.
Get the original writ petition file.
Ah.
Register that file.
Yes.
Take the original file of the writ petition and list the writ appeal for admission on 11th October.
My lord, interim may be
We'll consider 11th October.
Item number 18.
Yes, please.
One of the honorable single judge directed the regularization of the.
Why they have listed for orders? The service is complete. No. Okay, this is for admission. Okay. You find one. Yes, please.
My lord, this appeal has been directed against the, my lord, direction of the honorable single judge to regularize the service of the petitioner. My lord, that has been done on the basis of a submission at the time of hearing of the application that a similarly situated person's service has been regularized. If your lordship kindly comes to the impugned judgment, which starts at page 69, your lordship may kindly come to page 71.
Yes, please.
Mr. Nath submits that the petitioner has been continuously serving in the post of general attendant on temporary basis since the year 2004, notwithstanding the same, and despite the fact that the persons above him in the panel, namely Sri Subandhu Kumar Nath, has already been regularized in service, no action has been taken by the bank to regularize the petitioner's service. So, my lord, based on this submission, my lord, ultimately, in my lord, page 73, my lord, paragraph, third paragraph, the honorable single judge has observed that As noted above, the person appearing in serial number 1, namely Subhendu Kumar Nath, has already been regularized in service after his initial appointment as general attendant. So, my lord, on that basis, the direction has been issued. My submission before lordship is that, my lord, this fact that, my lord, in the panel, there was another person above him whose services have been regularized. This is, my lord, not in the pleadings. My lord, he has filed several representations. This was not his case, my lord, all through.
Where did it crop up from?
My lord, only at the time of hearing, my lord, this was submitted.
Oral submissions.
My lord, oral submission. And my lord, I have, my lord, in the.
What is your stand? All right, come on,
Our
come on to
stand
the
is that, my
factual
lord,
aspect.
Yes, my lord, our
Yes.
stand now in.
What
the-
have you said in the appeal?
My lord, in
What is the
appeal, my
position of
lord,
that employee?
If your lordship comes from his 13,
Yes.
my lord, ground B. Further, the regulation of Sri Subhendu Kumar Nath cannot be equated with that of the writ petitioner in as much as the two are not similarly situated.
Why not?
My lord, that has been explained, my lord. Unlike the writ petitioner, Sri Subhendu Nath had been working as a canteen boy with the State Bank of India from September 1990, as well as working as cleaner with the respondent bank since 1997. The regulation of Sri Subhendu Nath's service were carried out under the settlement dated 30th July 1996 between the State Bank of India and All India State Bank India Staff Federation, where it was clearly stated that while temporary employees in subordinate cadre out of a panel so prepared were to be given a chance for being considered for permanent appointment in the bank, against vacancies arising up to December 1994, daily wage casual employees out of a panel so prepared were to be considered against the vacancies arising from January 1995 to December 96. It is admitted position that the writ petitioner was initially working as a canteen boy on being engaged by the local implementation committee, which is an entity different from the respondent State Bank of India. Therefore, my lord, the State Bank could not
Yes.
get the opportunity.
What do you say, sir?
to raise this case.
There was no pleading. The respondents had no opportunity to respond.
My lord,
Yes.
at the time of hearing, my lord, I came across the salary slip of the particular petitioner. Kindly just have a look once, my lord. Although I have not, because this is sweeper, my lord, it's difficult for him to get the copy.
Doesn't matter.
With a lot
sir.
of difficulty. yes, for
Without,
this-
without pleadings being there,
Yes.
we'll
Lordship,
consider everything.
Yes, yes.
Sir,
Lordship,
without pleadings,
yes.
this is Shibhendu Nath.
Shibendu Nath, yes.
Maybe
Yes.
sir, they have given out their reasons why he was regularized, but they got no opportunity before the single bench.
Just one thing, my lord. 10 is the right side top and see the age of the Shibendu, my lord. Right side top date of
Sir,
birth,
we
13,
under-
79.
we-
Just for a moment, my lord.
We
please.
accept everything,
Yes.
but to be condemned unheard is not possible. Absolutely. Third land council.
Because only one thing, my lord. Because in paragraph 13, just let me read one thing, my lord. Paragraph 13, page number 13, my lord. Just
Yes.
one moment, my lord.
Sir,
the-
first show us your pleadings in the writ petition.
My lord, in my
You are
paragraph,
seeking parity on the basis of facts of a person, which aspect is never touched in your
my lord, so
pleadings.
far, this is not there. But in my paragraph 7, 8, 9, 10, I have all along prayed about regularization.
Yes, all right. Based
But-
on what? The relief has been granted solely on the ground that Shibhendu Nath has been.
That's true.
And they have given out several reasons
Yes.
why
my
why he was regularized.
Just want to say one thing, my lord. Shumendra Nath is working from September 1990. They pleaded in page 13, paragraph B. If you also find that order I have given you, he was 9 years, 11 months on that day, and he has
That-
considered the case for
That
regularization.
that aspect they would have to answer before the single judge, sir. Third learned counsel for the appellant learned and senior counsel representing the respondent. The instant intra-court writ appeal is directed against the judgment / final order dated 16/6/2023 passed by learned single judge whereby writ petition number so and so preferred by the respondent was accepted and the appellant bank was directed to regularize his services. Full stop. Learned counsel Mr. Chaudhary submits, senior counsel Mr. Chaudhary submits that the regularization was directed purely on the ground of purely drawing parity with one direction to regularize the services of the petitioner was issued purely drawing parity from the fact that another employee named Shibhendu Kumar Nath had been regularized in service after his initial appointment as a general attendant. Mr. Chaudhary submits that this ground was not pleaded in the writ petition and hence, the appellants never got an opportunity to counter the same, he has referred to several governments made in the writ appeal, portraying, projecting as to how and in what manner, the case of the respondent writ petitioner is totally distinguishable from that of Sibendu Kumar Nath. First up, Learned Senior Counsel Mr. Nath, representing the respondent, is not in a position to dispute the fact that the particular pertinent ground regarding parity in the cases of the appellant and Sibendu Kumar Nath was not raised in the writ petition. However, his submission is that the respondent writ petitioner has several other reasons / grounds for seeking a direction for regularization of his services. First up, we are of the opinion that as in the writ petition, there was no specific ground regarding regularization of services of Sibendu Nath, the appellant herein was precluded from responding to this pertinent ground on which the writ petition has been accepted. Hence, the writ appeal is allowed, heard on prayer for interim relief. There shall be a stay of the impugn order during pendency of the appeal.
There is no, my lord, I understand. My lord, there is, my lord, can one line be added? Can one line, my lord?
You
What-
can right now seek a relief of remand.
Yes,
We can remand it right now.
My lord,
that will be.
that- that's
Otherwise,
what I-
it will be stuck up.
My
for
lord,
years.
my lord, that's what I want to make a prayer, my lord. If
We
the
can
matter-
remand right now.
My
But
lord,
then there has to be a concession on your part. That yes, this ground was not taken and they could not respond to it.
because ultimately, my lord, ultimately, lordship is the way has just passed the order, my lord. The justice has to prevail, my lord. That is true. In fact, there's no pleading on my part, my lord.
Yes.
So if I can make a pleading in part, my lord, that can be
All
started again, my
right,
lord.
At this stage, where we have mentioned regarding the lack of pleadings, at this stage, Senior Counsel Mr. Nath, appearing for the respondent caveat, submits that no useful purpose would be served by keeping this writ appeal pending and thus, while interfering in the order of the learned single judge on the ground of lack of pleadings in the writ petition, the court may be pleased to remand the matter to the writ court with a liberty to the respondent writ petitioner to file additional pleadings on the aforesaid grounds.
I have no objection to that.
To this submission, Mr. M.K. Chaudhary, Senior Counsel representing the appellant, does not object in view of the discussion made here in above, the writ appeal succeeds and is thereby allowed. The impugn order is reversed. The matter is remitted to the learned single bench for fresh consideration and decision of the writ petition on merits. The respondent writ petitioner shall be at liberty to file additional pleadings to project his cause on the basis of parity with Sibendu Kumar Nath. The appellant bank will be given liberty to file an affidavit in opposition to such pleading. Additional affidavit. The writ appeal is allowed in these terms.
Obliged, my lord. Highly obliged. At least, my lord, some hopes.
Item number 19.
Yes.
Sir, this writ appeal is directed against the judgment and order dated 18/9/2023 by the Honorable Single Judge. My lords, the matter pertains to transfer. Now, my lords, in the judgment, my lords, palpably, my lords, the Honorable Single Judge proceeded on an incorrect premise, my lords. So what had happened, I'll very briefly narrate the background, my lords. On 17/10/2020, the respondent number 1, my lords, who was the writ petitioner, he was temporarily attached to the post of residential school coordinator, my lords. Thereafter, my lords, on 4/7/20.
My question is. Yes, please.
He was temporarily attached to that post, my lords. On 4/7/2023, the present appellant was transferred to that post, my lords, and the writ petitioner was transferred to a different post, my lords. Thereafter, the appellant already took charge of the post. After taking charge of the post, he files a writ petition before the honorable bench at Arunachal Pradesh, my lords. One of the many grounds, my lords, on which the honorable single judge had interfered, it was stated in the writ petition, my lords, that to discharge the duties of residential school coordinator, to which post I was transferred, I have to have a B.Ed degree, my lord. Although that was a guideline, my lord, not enforceable, but I'm not on that, my lord, for the moment, my lord. Now, what the honorable single judge has held, my lord, lordship would kindly come to page 29 directly, my lord, of the judgment and order, my lord.
Internal page number,
Page 29, my lord, internal page number 9.
paragraph.
Paragraph, my lord, it's not numbered.
It is numbered.
Page number 9, my lord. It starts from though the respondent number 4.
Yes, sir.
May I read, my lord?
Yes.
Though the respondent number 4 has contested the case of the petitioner by filing a detailed counter affidavit, yet in view of the specific contention of the petitioner that the respondent number 4 does not possess B.Ed degree, thus ineligible for posting as coordinator residential school, the original records containing the service book of the respondent number 4 was directed to be produced by the Learned Standing Council for the Education Department, by so-and-so, dated so-and-so, so-and-so. Pursuant thereto, the Learned Standing Council has produced the service book in original of the respondent number 4. On perusal thereof, it is noticed that though the respondent number 4 possesses B.Ed degree of B.Ed since 2017, however, the said fact was not, my lords, reflected in the service book of the respondent number 4 until 4th of August 2023, on which date an entry was made in the service book of the respondent number 4 that the respondent number 4 had completed B.Ed degree in the year 2017 from so-and-so. From the above, it is evident that on 4/7/2023, when the respondent number 3, Deputy Director so-and-so, Upper Subansiri so-and-so, had issued the impugn order dated 4/7/23, assigning the respondent number 4 the duty of coordinator, there was no material in the service book of the respondent number 4 that the respondent number 4 possesses the B.Ed degree. Now, my lords, would turn to page 159, my lords. It's a part of the affidavit in reply filed by the writ petitioner respondent number 159, my lords. Now, first of all, it is not the business of the
159 or 149?
159, my lord.
Yes.
My lord would see the date. It's 20th of April 2018. It is addressed to the Director of Elementary Education. I am submitting here with copies of the following teachers in respect. Number 1, Shri Tarak Edu, PRT. Shri Madik Mara, PRT. Number 3, Shri Tapo Sorum. Number 4, so-and-so. For this established for favor of a kind consideration. Lordship would see the subject, my lords. Submission of copies of B.Ed certificates and DPE certificates. Now, one, I'll just clarify. Lordship would see at number 3, the name is Tapo Sorun, but the name of the appellant here is Tapo Garam, my lords. Now, my lords, turn to page 101, my affidavit in opposition, my lords. Page 101 for a moment, just to clarify, my lords. Paragraph 4, my lords, 101.
Yes.
At the outset, the answering respondent number 4 begs to state that he has changed his name from Tapor Sorum to Tapor Goram in 2018 by executing an affidavit. So it's one and the same person, my lords. And my lords, one more submission, my lords. What business does the writ petitioner have to say, or what locus that the other person who's transferred to his post does not possess the qualification, admitting so, my lord. His duty, because transfer is an incidence of service. Now,
all right.
Allegation of malafide.
If he finds out that the person so transferred is not qualified to hold the post, why can't he raise that objection?
He raised, my lord, but his duty is to go to the post he's transferred.
All right.
He raised that objection. The department would take care of that objection, my lord. But I have shown from records, the honorable single judge has proceeded on a
We are
false
not
premise.
satisfied the manner in which you say your name change took place. Has it been gazetted? There's a requirement of gazette notification.
That was not disputed, my lord. Name changes.
We are not satisfied.
My lord, the
We'll
order
make
is
a
there.
comment.
The order is there, my lord.
Which order?
My lord, that at the outset, the answering respondent number begs to say that his name has been changed from so-and-so by executing an affidavit before a magistrate, and the same was also published in a local newspaper. Thereafter, on 12/06/2018, the Director of Elementary Education issued an order where it was stated henceforth that order is there, my lords. A copy of the order dated 12/06/2018 is annexed here. It is marked as annexure H. I'll just point out that order, my lord. The name was not a dispute at all, my lord. That's my lord, that page 115. Consequent upon execution of affidavit before executive judicial magistrate so-and-so by so-and-so, subsequent publication so-and-so, the surname title Sorum is changed with the name Tapor Sorum PRT serving in the established location and declared his or henceforth name as Shri Tapor Garam instead of Tapor Sorum. Now, my lord, he possessed the B.Ed degree way back in the year 2017. In fact, the same authority, the deputy director who has issued the transfer order, he had transferred his record to the director, my lord. So the question of him not having the knowledge that he is a B.Ed, my lord, it does not arise at all. Of course, my lord, it's not added in the service book, my lord. To add things in the service book takes time.
There is a requirement of the person having that B.Ed degree.
That's a guidelines, my lords. My lords would find the guidelines. My lord, person
Page 59.
59, my lord. Thank you. For that. 59, point number 12. Even
These are guidelines which have to be followed. On qualifications, if there are guidelines, they have to be followed.
Yes,
In any event, what your argument is that he was having the qualification. What do you say, Mr. Nair?
My lord.
Here, non-entry in the service book is not his fault.
My
But
lord.
the fact only is that he should be having that degree. And he has given that empirical evidence
My lord.
of having the degree.
My lord,
Yes.
page 59 says, my lord, that, my lord, along with my lord, may I read, my lord?
Yes.
The EC has approved for appointment of BRC, CRC district coordinators for different interventions from teachers with sound academic background only with 10 years teaching experience with B.Ed.
Yes.
So, my lord, the submission before the learned single judge was that this 10 years teaching experience should be post B.Ed.
No.
But, my lord, that was the submission before the
absurd.
learned single judge.
Absurd.
But the main leg of the arguments before the learned single judge, if my lord comes to the impugned order at page 8.
We have seen, if there was a requirement of B.Ed,
My lord,
then it was not entered in the service record.
my lord, that
It
is,
doesn't
one
matter.
part. My lord, there is another part.
Yes.
My lord may come to the impugned order at page
Yes, please.
86, my lord.
Yes. Para,
My lord, this is the order, impugned order, my lord.
impugn order.
My
Let's-
lord.
transfer.
This is dated 4th of July,
Page 86.
page 86, 4th of July.
Yes.
My lord will see the remarks column, sorry. My lord will see the 4th column, remarks. This is the writ petitioner. He is relieved from coordinator residential school and directed to assume the charge of new assigned. Further, he is directed to hand over charge to the new incumbent within 3 days of issuing the
Yes.
order, failing which an ex parte charge will automatically be taken.
Yes.
My lord, there are pleadings in the writ petition, my lord, that this particular respondent number 5, who acted as the deputy director of school education, my lord, he joined on 3rd of July, 2023. He passed this impugned order on 4th of July,
Interference has not been made on Malafites.
not on Malafites, but this was my
Interference is simply on this ground,
My lord.
sole ground, he is
My-
not having that qualification.
My lord, that is.
Can't be sustained, sir.
My lord,
Admit issue notice, stay.
I'm very
I have
grateful,
already
madam.
joined, my lord, pursuant to the single judge's order.
He'll have to be relieved.
Deeply obliged. Very grateful.
Deeply obliged.
He is actually having that. Yes.
Item number 20.
Obliged.
Yes, please, Your Lordship.
Yes,
Here
please.
we have challenged the order of the honorable single judge, my lord. Here, my lord, this matter is to compassionate appointment. Here, my lord, we have annexed 3 orders, my lord. Your Lordship may kindly peruse 3 orders. One is at page 44, my lord. This is the first order,
Yes.
page 44. There are 3. It is submitted that the father of the petitioner, late Sivakumar Patil, died in harness on 25/2/2000 while he was working as sub-inspector of police in the district of Sivasagar. It is submitted by the learned counsel for the petitioner that the petitioner belongs to a
Madam,
recognized.
madam, what instruction is
Here, my
required?
lord,
What
was
instruction is
sought.
required?
And
You have filed the petition after 23 years.
my
What
lord,
instruction is required?
Your lordship, instruction was required
We are not,
whether her case was ever placed before the DLC.
why did you
Then
keep on
in the-
sleeping for 23 years?
No, my lord, the petition, the delay was committed by the respondents, and in your lordship may kindly see the next order at page
We
47.
have
my
seen
lord.
that.
Here,
What
my
are-
lord, the
where are your-
instruction was not
Where are
received.
your communications in the intervening? period?
Communications are there, my lord.
Let us see.
The
Let's
last
see.
communication was at,
That page
that
number,
is at page 39, my lord,
let's see.
of
Yes,
2007, my lord.
yes,
In fact,
2000.
the petitioner, he resides at Dhemaji and her father died in Sipsagar, my lord. So she applied in Dhemaji
Sorry,
and it was
that can't
communicated,
be.
it was communicated by the deputy commissioner of
Where is
Dhemaji.
your communication to the authorities that my case has not been considered?
My lord, that is, my lord, replies are there, my lord. My lord, it is very much reflected in their, my lord, communications. My lord, it was submitted before the Dhemaji, my lord. The deputy commissioner of the Dhemaji communicated it, forwarded it after 3 years, my lord, to the deputy commissioner
Yes.
Sivsagar.
So you should have come to the red court at that point of time.
2007, my lord.
Dismiss. Thank you.
deeply obliged, my lord.
We have compassionate appointment delay. अभी judgment क्या होगा? दे दीजिए.
Item number 21.
And before starting by my learned friend, my appellant, I know have been served a copy of the memo.
You have not received a copy.
I have not served. He's challenging my order, but copy was not.
No, your lordship, that IA was, your lordship, notice was issued on IA, your lordship,
Are you IA for?
for condonation or your
Okay.
leave, and
Condonation
therefore your
and
lordship somehow. I will furnish your lordship copy.
You represent
I'm representing my writ petitioner, respond number 4.
the council, Mr. Potako, to provide a copy of the writ appeal to land council representing the respondent number 4, Mr. Pegu. List for admission after 1 week.
Lord. I will, sir.
Item number 22.
May I please?
Yes, please. What is this about?
Lordship, the petitioner, your lordship, here in your lordship. Matter relates to selection and appointment.
Right.
Assam Judicial Service Gate 3 examination. Your lordship. He is a candidate, your lordship, under PWBD category, your lordship blind, your lordship. Now, if your lordship comes to the advertisement, your lordship,
Yes, please.
that is at page 19, your lordship. This is the advertisement, your lordship. This says, your lordship,
Yes.
category of breakup of post, your lordship, and then your lordship, just below that, reservation for
PWBD can,
will
yes.
be made as per rules, your lordship. And then your lordship, candidates seeking relaxation under PWBD category must be from locomotor disabled category.
Yes,
only.
yes.
Then your lordship, when this was, your lordship,
Challenge.
published, your lordship, I did not challenge it, your lordship. Rather, your lordship, I filed an application before the register, your lordship, saying that it should not be limited to PWD locomotor only, and the blind category candidates should also be allowed to participate in the selection. Then your lordship, a corrigendum was issued, your lordship, that is at page 28.
28. Yes.
It says in partial modification of earlier advertisement number so and so, that is 6/2023, Guwahati High Court has been pleased to notify that all candidates seeking relaxation under PWBD
Allowed to apply.
apply.
All right. Yes.
Then your lordship. Then your lordship, I applied, your lordship, and my mark is, your lordship, that is at page 32, serial number 798/65.
Williams.
65, that is just above the, your lordship.
Right. But you've been treated under the undeserved category.
Lord.
You're not been given the relaxation.
Relaxation, your
Then-
lordship, not given the relaxation, then your lordship, that stage I came before this honorable court, your lordship. When the written examination was notified, your lordship, I was not called for the interview, and your lordship, this honorable court, I allowed me to
That's
participate.
all right. That's right.
That is your lordship. Now, your lordship, then your lordship, in the meanwhile, your lordship, the High Court has filed their affidavit, your lordship. And in their affidavit, your lordship, specific pleas, your lordship, were taken, your lordship, at para 11, and your lordship,
para 12.
Yes,
These are the, and they have also relied on your lordship. A report, your lordship, of the resolution of the meeting of the committee for recruitment of judicial officers, your lordship.
Yes, please.
Now, your lordship, if your lordship come to para 6, page 11, your lordship, of the
Yes.
affidavit, your lordship. May I read this, your lordship?
Para 11, read
Para-
first para 11. Yes.
That with regard to the statements made in paragraph 13 of the read petition, the answering respondents, while denying the contention made therein, begs to state that instant process of recruitment, no post was reserved for PWBD category and post in respect of Assam Judicial Service yet to be identified. This is the
Next line, next line.
The next.
It is further stated that as per resolution dated 7/3/2019, it was resolved that only locomotor disabled candidates are fit for judicial service.
Yes.
Therefore, taking into consideration the said resolution dated 7/3/2019, the advertisement dated 6/2/2023 was published, allowing only locomotor disabled category, PWBD category to submit their candidature.
Yes.
Now, this is the, your lordship.
Carry on, carry on. Read the full para.
In this context, it is pertinent to mention here in that already communication dated 27/6/2023 was issued to the government of Assam, requesting for identification of post of persons with benchmark disabilities in Assam Judicial Service. The addendum dated 14/3/2022 was issued because in their earlier recruitment process held in the year 2019 and 21, the posts were open for all categories of PWD.
Open. So all right, the competition is open.
Open.
Qualify on your own merit.
Lordship.
That's right. But no reservation.
Lordship, that your lordship, in my humble submission, that
That was not challenged before participating.
Lordship will kindly see your
Yes.
lordship, the fact that your lordship, they have said your lordship that it will be reservation will be as per PWBD rules,
Yes.
your act. your
Which
lordship.
permit the
Therefore, your
employer,
lordship-
Mr. Botakur.
Lordship.
The rules permit the employer to identify the posts for the particular assignment or the job.
Lordship.
They have identified locomotor disability as the only post,
Now your
only disability which is suitable for the post.
now your lordship may kindly take up the act, your lordship,
Yes.
2016 Act,
Yes,
section 32 and 33. your
yes,
lordship.
yes.
33 and 34, your lordship. RDR Act 1996, it was 32 and 33. Now in 2016 Act, your lordship, this is 33 and 34.
Yes.
Identification of post for reservation, your lordship.
Yes.
The appropriate government shall
Yes.
identify post in the establishment which can be held by respective category of persons with benchmark disabilities in respect of the vacancies reserved in accordance with the provision of section 34. Now, constitute an expert committee with representation of persons with benchmark disabilities for identification of such posts and undertake periodic review of the identified post in an interval of not exceeding 3 years, your lordship. Now, with this, your lordship, first of all, your lordship, the committee that has been constituted by this honorable court, your lordship, that is not as per the mandate of this particular act, number one, your lordship. Number two, your lordship, this will have to be periodic review of 3 years. Automatically, your lordship, the earlier reports, your lordship, has your lordship lost its, your lordship, validity, your lordship. Because your lordship, if your lordship takes up the affidavit again for a moment, these are your lordship will find. One is your lordship report is dated 7/3/2019.
Yes. Which is the appropriate government for the purposes of this recruitment? Is
That
the High
your
Court?
lordship- That is the state government, because
State
your lordship, this on the High Court itself has written to the state government for identifying
So
the.
that's what we are saying.
Lordship.
That your mandamus is being sought against the state government or against whom?
No, your, at this point, your lordship, what was my prayer, your lordship, that I should be allowed to participate in this?
That you have done,
Yes.
that you've done, but for you to get the benefit of reservation, there has to be a declaration before or you should have challenged it before the notification was issued or immediately on the issuance of the notification.
Lordship.
Because if we allow reservation to one candidate of this category,
Lordship.
that means we are lowering the bar for a particular category, for a particular candidate. If at all this relaxation is to be provided, reservation is to be provided, all candidates of the same category should have been given a permission.
Lordship.
You did not challenge it at that point of time. It was only locomotor.
Lordship, your lordship will kindly see that your lordship, the advertisement says your lordship, it will be as per your lordship, PWBD Act.
There is a qualification, locomotor.
Then your lordship, the notification, the corrigendum issued, your lordship, if we read all together, your lordship.
No, corrigendum only for the purpose of relaxation in age and marks. That is what they have said.
If your lordship will kindly go to the advertisement again, your lordship.
Yes, please.
Your lordship. Your lordship will find
Hmm.
in the advertisement,
Yes.
reservation for PWBD categories will be made as per rules. Then there is a full stop and then your lordship candidates seeking relaxation under PWBD category must be from local.
Yes, yes.
Then
yes.
seeking relaxation, your lordship.
Hmm.
Now your lordship, when the corrigendum was issued,
So whether you have taken benefit of relaxation?
no, your
Let's
lordship,
see, color relaxation, what is the corrigendum?
only age, your lordship.
Yes.
Age I have taken, your lordship.
So then, as per the original advertisement, you are not even entitled to relaxation under age of age. Corrigendum also restricts its field of operation to relaxation, not reservation. Reservation providing or identifying the posts is the job of the state government. It has not done, it is not done.
Then your lordship will kindly see if that has not been done, your lordship. That is virtually, your lordship, the virtually the provision of Act, section 34, will become obvious, your lordship. There is no application of this. And your lordship, one judgment of the Honorable Apex Court
Yes.
is there, which
Yes.
says, your lordship,
Yes.
that section 32, earlier 1996 Act, your lordship.
It's
section
there,
32 is-
it's there. How do you account for lack of reservation in this?
My lord,
process?
I'll do. My lord, when this posts were being done, the committee of this High Court set up
Hmm.
temporarily that this post, it's there in the minutes, my lord, that a person who is visually impaired
Hmm.
would not be suitable
Suitable.
because he will not be in a position, it's not for any other reason, my lord. He will not be in a position to understand the demeanor of the witness.
We have a judicial officer working in Rajasthan.
Rest-
He's been promoted to grade 2 now, grade 3, grade 1 most likely.
But my
Grade
lord,
1, yes.
But this was the view taken,
Hmm.
and my lord, it was found that locomotor disability is fine.
Hmm.
They would be in a
But
position.
whether you provided reservation to locomotor as well.
My lord, locomotor was there, but in the current
Reservation,
reservation, my lord.
where is it? Read.
My lord, no, in the current, in the stand in the affidavit is, in the current recruitment process, there is no relaxation, reservation for any of the locomotor also, my lord.
What is the reason?
Because that it does not work out. That was the stand taken. My lord, I'm on a different, this is on a different footing altogether, my lord,
Mhm.
this matter.
Okay.
My lord, he appeared in this election.
Hmm.
My lord will see in the act, there is reservation provided for,
Hmm.
there is no relaxation provided for. The
Relaxation
relaxation is
is-
only to the extent of age and my lord, fees,
Fees, okay,
fees submitted.
right.
Now, he will have to, because this is right from Indra Shawne,
Hmm.
this is my lord horizontal.
Horizontal.
reservation.
Yes.
So he is a general category candidate.
Hmm.
So he will have to
That's
achieve.
what he is challenging, that your notification without making any reservation for PWBD is bad.
No,
You
that
are
is not,
mandatorily required. Read
I'm sorry, my
34.
lord, that is not his prayer, my lord.
Yes, yes.
My lord
Read
would see,
34, Ms. Prayer,
no, my lord, page 15, his prayer, my lord,
15.
lordship.
Let's see. Even if it is not a prayer,
Lordship.
that is a ground based on pure law point.
Law point,
34, read 34,
page 34, my lord.
Section 34.
My lord,
Hmm.
we have
No, he has asked for reservation. A, ground A, that is the ground.
lordship,
Read.
34, my lord.
No, para 22, prayer clause of the writ petition, then read 34, section.
To provide the petitioner with marks relaxation and reservation as guaranteed under section 20.
And reservation.
And reservation.
So he
But,
asked
my
for
lord,
two things.
we have now taken a call, at least there is a resolution, now I have brought it on record,
Hmm.
wherein we have said that this reservation will be for locomotor only, my lord, not for any other
That is
category.
post the issuance of the.
No,
writ.
no,
Then,
before that, it is in 2017, my lord.
okay,
That
let's see.
decision, my lord would have the affidavit.
Where is that?
There are two decisions, my lord. The first decision I'll take, my lord, that is that,
Mr. Nair, then you were supposed to indicate this in the advertisement. Why didn't you do that?
my lord, advertisement, we said, because my lord, we said we will give relaxation only to locomotor, because that's the
Relaxation. See, relaxation and reservation are two different.
My lord, the stand taken is,
Yes.
they therefore, my
How many
lord,
were the posts advertised?
lordship,
How many posts were
my lord,
advertised?
in total 33, my lord.
33.
30.
So 4% works out to
4%, one, my lord.
or more. 10.
4% would be, my lord,
Just let's see. What does 4% work out?
1.3 to 1.
One.
One.
So one post Where is your resolution?
My lord would have,
Have you got any candidate from that category?
no, no,
No.
no.
Okay. So by virtue of horizontal reservation, that post go to general category?
That will go to general category.
Okay.
Now, my lord, the first resolution, my lord would find at running page 64.
63,
64, my lord.
4, okay.
My lord would have page 65, the second paragraph after the bold, my lord, second paragraph. The committee also discussed the issue relating to category of disabled persons can perform the duties of a judicial officer. Basically, all the judicial officers are required to hear the cases, record evidence, look into the nature of the evidence, and thereafter to deliver judgment after appreciating the evidence. In a trial court proceeding, observation of a demeanor of a witness, amongst others, is of much significance. Hence, persons who are blind or with low vision and person with hearing impairment may not be suitable for recruitment in judicial service as of now.
Right.
On the other hand, in the opinion of the committee, the persons with locomotor disability may perform the duties of a judicial officer without much difficulty. Hence, the committee resolves that required vacancies reserved for persons with disabilities in judicial service under this High Court should be with locomotor disability with following physical requirement and disablements. My lord, that was prescribed. And my lord, in all our advertisements, we have been doing this. Now, my lord, what had happened in the current advertisement?
Yes. Let's see.
My lord would have page 19.
Yes.
My lord, after the breakup of vacancies, reservation for PWPD candidates will be made as per rules. My lord, in the rules, there is no provision for relaxation or
Rules
reservation.
means got a court.
They know, my lord,
Service.
the Assam Judicial Service rules.
Assam judicial.
So, my lord, that would be read as the resolutions of the Judges Committee.
Judges Committee.
So that would be added there, my lord. It would be a part of that. So that is locomotor. But my lord, when the petitioner submitted an application, my lord, it was
Mr. Nair,
lordship,
the rules cannot supersede or override the provisions of the act.
lordship.
So if the act says 4% reservation to be provided, where is your reservation in the?
My lord, the resolutions that are there, it says 4% for locomotor, my lord. But
Just
here
hold
in
on,
this,
hold on. Read the distribution, count them.
lordship,
18 plus 4 plus 3 plus 8.
8.
That goes to 33.
33.
So where is the seat reserved for locomotor?
My lord, it will not come here, my lord. It
Why?
will be a general reservation of 4%. Whoever comes in, my lord, that one person, he may be an SC, he may be an ST, he may be a general. If he has that, my lord,
Okay,
then he will come and
we'll
occupy
come
that.
into that, occupy that post. Okay.
One of those, my lord, SC would be removed, or one ST would be removed, or a general would be removed,
Okay.
and he will come.
He will come into that.
That is horizontal reservation.
All right, okay.
If some locomotor candidate comes up tomorrow, my lord, he will have that, my lord. He'll get that.
Okay.
But unfortunately, this time, even for that, it was not there. That is my instruction. One, my lord. Two, he scored 65. The rules require that you must have 60 plus, my lord. But there is a proviso there too. Even in the advertisement, it is provided that people will be called in the ratio 1:10 for each vacancy.
Okay.
So 18 vacancies for general, 1:10, 180 people will be called. So when we call that, the cutoff came to 72, my lord.
Okay.
So he has not achieved that.
Achieved that.
Now, my lord, there is no provision for giving relaxation on merit in this election process to PWDs. my lord. If my friend can show that, nothing like it.
Let's see. Let's
In
see.
the act also, my lord,
Yes,
would say
let's
there is
see.
nothing.
Let's see that. Yes. Yes.
That's
Show that. Yes. Relaxation
34,
in
my lord.
marks. Yes.
34. Reservation,
Reservation.
34, my lord.
Yes.
Every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group or post meant to be filled with persons with benchmark disabilities, of which 1% each shall be reserved for person with benchmark disabilities under clause A, B, C, and 1% for person with benchmark disabilities under D and E, namely, so and so. Provided that reservation and promotion, that is not attracted.
No, that's
Further, my lord,
Yes.
provided further that the appropriate government in consultation with the chief commissioner or state commissioner, as the case may be, having regard to the type of work, my lord, that is exemption.
Exemption.
Then two, my lord. Where in any recruitment year, any vacancy cannot be filled up due to non-availability of person with suitable benchmark disability,
Carried forward.
oh,
Carry
it shall be carried forward.
Hmm.
But my lord would find not even a whisper here of my lord relaxation.
Relaxation in marks.
It's not there, my lord.
Lordship will kindly see your lordship.
And my lord, one more, the three, my lord.
Hmm.
My lord is having 34(3).
Hmm.
The appropriate government may by notification provide for
Relaxation
such
of-
relaxation of
Correct,
upper age
correct.
limit for employment of
So
person
the-
with benchmark disability as it's think fit.
So relaxation is only in
Only for
age.
age, and we have
and
given
fees,
fee also.
fees.
That is there, your lordship. Now, your lordship, so far as this mark is concerned, your lordship,
Hmm.
cutoff mark is concerned,
Hmm.
since it is a horizontal reservation, your
Yes.
lordship will kindly see, your lordship. Your lordship, surpasses the mark, your lordship, that the minimum eligibility of 60 marks, your lordship.
That's all right,
No,
but
no,
they are
your-
supposed to call in the ratio of 1:10.
No, your
You
lordship
don't
will
come in
kindly
that.
see, then your lordship, there is no scheme of reservation at all for
Welcome.
this, your lordship. Now, your
Yes.
lordship will kindly
They
see.
don't give you relaxation in marks.
No,
You want addition of 7 marks.
no,
to come into that zone.
I don't need your lordship, because your lordship, since it is a horizontal, your lordship,
Yes, yes.
reservation.
How many
the
candidates will
last
they
man-
call?
Last man,
How many-
72,
how-
your lordship.
How
Now,
many candidates will they call?
72, your
No,
lordship.
no, no. 193. my lord.
Four out of your
For
lordship, 18
interviews,
general.
for interviews or for final
Viva.
exam?
Viva.
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 How many
Not for-
candidates?
No, sorry, my lord, for
Written
written
That is for
exam.
final examination.
Written
Written
examination.
Yes,
Unreserved, 193.
193.
193, your lordship. Now, your lordship, the last man in this 193, your lordship, he will be out, your lordship. That is the horizontal reservation, your lordship.
No.
Your lordship will kindly see, the last man will be out and the person from the horizontal
kind.
reservation will come in. Now,
That
if that is not the case, your lordship, then what is the meaning of this reservation for
Yes, you
PWBD?
don't get any relaxation in marks. Compete, get marks, and one post is reserved for you.
No, that,
So in interviews, supposing you don't score anything, then also you will come.
with utmost humility, your lordship, probably that is not what is the scheme of horizontal
Show us
reservation.
the
is, your
judgment,
lordship.
show us any law to the contrary.
Yes, your lordship, that then your lordship may fix it some other day, your lordship, I'll show that.
My lord,
That is not
I'll
the-
satisfy your lordship on that.
No,
lord,
let me satisfy
Today, my
your
lord
lordship.
is providing for a relaxation.
Hmm.
That means my lord is identifying a reservation there. My lord, that will become akin to SC, ST reservation,
that's
OBC
right.
reservation. It will become a vertical
No,
reservation.
no,
my lord.
no.
It will not be a horizontal reservation, my lord. If it is to
Yes,
be a
but of course,
horizontal reservation,
If there is no relaxation in marks provided into the act, how can you be brought in? Tell us.
Lordship will kindly see your lordship.
Hmm.
The moment your lordship horizontal reservation.
There are
comes
two
in-
difficulties by your
Lord.
client. One, the committee has taken a decision that person with locomotor disability is only suitable. That is one difficulty. And the second is regarding relaxation in marks.
Now, your lordship, as per your lordship, section 33, your lordship,
Yes.
that report, your lordship has lost its, your lordship, validity, because.
So there is no
within
report
every
then.
3 years.
As on date, there is no report.
no
No,
report.
and
No
that's
reservation.
why your lordship,
So will we quash the entire advertisement?
Your
What
lordship
what
will
will,
kindly see this judgment, your lordship. This
Yes.
judgment, your lordship says, your lordship. This is by your lordship, this is 2010, 7.
Mr. Nair, Mr. Nair,
Lordship.
what we'll do is we'll keep one post vacant. You proceed with the other interviews. I think that's the best way.
Okay.
All right, let him make his submissions.
Lordship.
All right.
My lord, his papers we will evaluate. We'll keep it in
evaluate.
seal cover.
Keep in seal cover. Yes. Arguments were heard. Arguments advanced by learned counsel for the petitioner and senior counsel, Mr. Nair, representing the respondent, High Court, were heard. Mr. Nair pointed out that the only relaxation which is provided to PWBD category candidates under the Act of 2016 is in relation to age. The advertisement dated 6 February 2023
And the origin.
clearly indicated that the candidates seeking relaxation under PWBD category must be from the locomotor disabled category only. This expression was made on the basis of the resolution taken by the Committee for Recruitment of Judicial Officers in its minutes dated 17th May 2017, wherein, the persons with locomotor disability were identified as suitable to perform duties of a judicial officer. Mr. Nair further submitted that the appellant herein, petitioner herein, secured how many marks?
65.
65 marks in the shortlisting examination, and thus, he does not fall into the category of 190,
My lord,
How many can-
193 unreserved.
93 candidates who were invited to attempt the final written examination, applying the ratio of 1:10 as per the rules. He urges that though the appellant, the petitioner has been allowed to participate in the written examination by virtue of this court's interim direction, in view of the fact that he has not secured the requisite number of marks within bracket 72, so as to come in the category of 192, 193 candidates within bracket referred to supra, the petitioner is not entitled to the relief claim for. Mr. Botakur prays for some more time to address the court on this issue. Mr. Nair submits that the entire recruitment process is stalled because the petitioner's answer sheets have not been evaluated. Have not been evaluated.
No, my lord, there is no stay. It's in the process of being evaluated. There is no stay to.
May be stalled if the may be stalled because the petitioner's result has been directed to be kept in a sealed cover. In view of the peculiar facts noted above, we permit the respondent High Court to proceed with the selection process for 17 out of the 18 unreserved category posts. However, the 18th post shall be kept vacant till disposal of this writ petition, till next date of listing. Re-notify after 3 weeks.
My lord will also claim that unreserved 17 and the other reserved post.
And the other reserve posts, other reserve posts.
Much appreciated.
Item 23.
What is this PIL 2021? What is this PIL about, Mr. Chaudhary?
Lordship, here the petitioner has alleged some irregularities with regard to a particular tender in Assam Sikh Corporation, whereupon he has submitted some false document, and later on he took away the tender amount money. And Lordship, subsequently.
You have given the inquiry report to the petitioner's counsel?
Yes, on the last occasion.
All right, copy of the inquiry report has been provided to land counsel for the petitioner in terms of the order dated 28/8/23. No one is present to argue the matter when the case was called out. List after 6 weeks.
Item number 24.
This case, your lordship, I need some time today. I could not prepare the matter.
What is the matter, Mr. Sakya?
Challenging the honorable single judge's order. The right to user acquisition by Act 1962.
Okay.
The gazette notifications were issued under section 3 and 6.
Acquisition for what purpose?
For
Laying
laying the
Pipeline.
Barani to Guwahati, that's a flagship.
Okay, so the procedure is stalled.
No, your
No,
lordship.
that's been
That
various. orders
Only
have been
issue
con-
relating to compensation.
Compensation, all right. Then let him have the instructions. Let him prepare them.
Lordship.
Let Mr. Botakur, representing the private respondent, prays for time to prepare and argue the matter. Mr. PG Sakya, senior advocate representing the appellant, does not object. List after 4 weeks.
Deeply obliged.
Item number 25.
In this case, Lordship, this matter pertains to this NHPC lawsuit, Lower Subansiri Construction Lordship. In
yes,
this
yes.
case, Lordship, we have found some, after receiving the affidavit of opposition, we have found some relevant things, Lordship, then that we have filed it today, Lordship. We have filed an affidavit, Lordship.
Some additional documents you
Yes,
filed.
Lordship.
Okay.
So we have served a copy also to my learned senior counsel, Lordship.
Yes, my lord, I have got the copy. My lord, could it be on Monday, my lord? I will seek some clarification.
Then
Because,
counsel for the
the portal,
appellant submits that he has come across some additional material which is relevant for deciding, relevant to the controversy at hand, which has been filed today. And senior counsel, Ms. Tiwari, representing the respondents prays for short opportunity to complete his instructions. Re-notify on 11th,
Wednesday. Sir.
it's all right, my lord.
11th. Yes, please.
Much obliged.
Password meter, item 11.
But in this case, by an earlier order dated 15/3. Okay.
Order dated?
15/5, madam.
Hmm.
The authority directed to consider my case for payment of the pension
Okay.
as per the clause 4A of the office memorandum
And this is there.
within a certain period.
Hmm. So they passed an order dated 31st August. You not got a copy? Why didn't you provide a copy, madam?
This is an order, this is an order, my lord, whereby, my lord, this my lord, administrative reform and training, my lord, and pension and public grievances department has,
Yes.
my lord, cleared their case, my lord,
Cleared the case.
cleared the case.
Okay.
The actual order yet to be passed by the, my lord, general administrative department. They have, my lord,
GAD.
JD, my lord.
Madam, when will the GAD take a decision on this?
Lordship, I'm appearing for the GAD. On
Yes.
8th, my lordship, on 8th, we had given to the pension and public events. On 31st August, they have passed this order. So it is in process, your lordship. Will be passing.
The senior counsel, Mr. Saikia submits that the GAD is required to take a decision on the order dated 31st August 2023. Until such decision is taken, the petitioner appellant herein, grievances raised by the appellant in this writ petition will not be ventilated. Then counsel representing the GAD submits that the matter is under process and a final decision is likely to be taken within next 4 weeks. Re-notify on 16th November.
Top of the list matters, item 3 and 4.
What is the matter about?
Your lordship, may kindly take item 4, my lord. Actually, both of the cases are different. So
Hmm?
it's your lordship to take up item 4 first.
Yes, please.
And regarding, they have approached this court earlier, my lord. And
please,
my
your
lord, in 2005.
In item number 3 and 4, my senior is unavailable today due to his personal difficulty for Assam Cooperative.
Who is appearing?
For cooperative union, that's, my lord, that is not a, my lord, important, my lord.
Who you are representing whom?
Assam State Cooperative Union.
Oh, that is a formal party.
Formal party, yes, exactly. my lord.
Cooperative department. You are cooperative for the cooperative department.
Cooperative department.
The contest is basically between the department and these persons.
Finance, no, my lord. They are also not.
Is the union, your lord.
Okay, funding authority is the union.
Finance, my lord, because the register has written to release certain amounts. And even the, my lord, commissioner approved, minister approved, but the amount has not been released by, my lord, the finance department. So main contest is the finance department.
Finance, who is there for finance?
Finance department.
This is good. So your contest is basically they are not entitled to anything from the state. That is what your stand is, yes. When? Today? You have made a request.
Yesterday, we contacted
the opposite party. Formal party বুলি কৈছে নহয়।
What Madam says is correct. The appointment is not an issue here. Issue is who is liable to bear the brunt of the wages, salary. It's the corporation. So cooperative department is here.
Yes,
No,
madam,
but
he is representing.
Your case is that they should bear the salary and everything.
Yes,
And of course, their version is to be heard.
yes.
All right.
Page, Lordship, may I kindly see page 73, my lord.
Okay, 73. Yes.
A letter was written long back in 2016, my lord. 19 December 2016 by the Commissioner and Secretary to the, my lord, Register of Cooperative Society.
73.
Page 73. Here, my lord, that subject is proposal for supplementary demand of rupees so and so, Assam Cooperative Union for payment of area authorized to see so and so and so and so, Registry of the Assam State Cooperative Union. This letter is written by the, my lord, by the Register of Cooperative Society to the Commissioner and Secretary. In inviting a reference to the letter on the subject cited above, I have the honor to say that the Honorable Guwahati High Court filed judgment and order dated 23rd March 2012 in contempt case number so and so had ordered the respondents, that is Principal Secretary to the Government of Assam, Government Register of Cooperative Society of Assam, and the Chief Executive Officer Assam State Cooperative Union so and so Guwahati to pay salary as per rule. Subsequently, the government filed a case.
So where are those two orders you are referring, which are referred to in this letter? Do you have a copy of these orders?
Copy of the
Order dated
yes,
24/2/2006.
Later on, I'll come, my lord. The Chief Executive Officer Assam so and so, so and so, so and so, so and so. So, my lord, certain amount was, my lord. In partial to this, my lord, actually, they have approached this court in 2005. If your lordship see, page 74, first para, my lord, that you are therefore requested to kindly take necessary action for according sanction so and so, so and so, only for clearance of area salary of so and so, so and so. And
So that was a one-time measure.
with the order of the Honorable Guwahati High Court, WPC number 7086 of 2005. So, my lord, in 2005, they got an order. Thereafter, appeal was filed, but two appeal was filed. Both the appeal were dismissed. Here, my lord, I am coming to the order of 2005. This is the basic order.
Yes.
The relevant paragraph is as a page 52. WPC number 7086 of 2005, order 24 February 2006. Here, madam, that third para I'm reading. According to the petitioners, they are similarly situated to other employees who are having the same qualification and are discharging the same work, however, only ground taken by the civil officer that upgradation in the post of residue being accepted but still by.
Madam, in this order, there is no discussion whether the state government is liable to make the payment or not.
Yes.
But direction has been given. But now they contest that the state is not the employer. That was not the issue before the single bench in that case.
Then my lord, state file and cooperative government file an edit appeal. And my lord, the union also filed an appeal. One was dismissed and my lord, both the petition was dismissed. One was delayed down.
Will you please listen to us, madam?
That order.
Will you please listen to us?
Yes, ma'am.
In that writ petition, there was no controversy regarding the liability of the state to pay. A direction was given, all right, state will pay. That's a different thing. Now they are contesting your case, saying that the state is not the employer. The union is the employer, let the union pay. On that aspect, argue.
The amount come from the state, my lord, since the.
What is the ground for saying so?
1961, the union was established.
Yes.
1961.
Yes.
Since 1961, the payment was made by the state only.
The state may have been benevolent. That's not the question. What is the liability of the state to pay when the employees are not the employees of the state government? Read the judgment of the single bench. Let's read the judgment.
Yes.
Yes.
53, madam, last paragraph. After hearing the learned counsel for the parties, the writ petition is disposed of. with a direction to the respondents to expedite the issue of payment of regular salary to the petitioners, and such regular salaries shall have to be paid from the financial year so and so for the purpose of the will start paying regular salaries to the petitioners
for
after allocation
financial
of fund,
assistance.
and the respond number 2 and 3 shall allocate separate
We
funds
got a
so
regular
that
budget.
discrimination apparently may not occur in respect of the payment to the petitioners, more particularly in comparison to the regular salary for discharging identical work and duties like other similarly situated person. The state government shall release the fund expeditiously for the purpose, and after allocation of fund, immediately the payment of regular salary shall have to be stated to be paid to the petitioner's portal. So appeal was filed, appeal was dismissed in 2009. So thereafter they filed the contempt, and my lord, in contempt also, my lord, they have submitted that they are making preparation for payment. Complaint order page 57, it is submitted by counsel for respondent to then the question has already been complied with by financial benefits to the petitions, including revised salary, take the revised scale of pay, this list. Thereafter, my lord, they have, my lord, the deputy secretary pays 59, my lord. The deputy secretary to the government of some cooperation department, he has written, my lord, on 12 March 2012, that with reference to the finance stealing so and so as financial assistance, so cooperative so and so, area salary out of the sanction amount of plans and so and so. This is the approval of principal secretary cooperation department. So department is, my lord, not disputing. Principal secretary cooperation department. So how the question arises if a lordship, my lord, I have filed here at page 79, the undersecretary cooperation department writing to the finance department that approval of honorable minister cooperation department so and so finance department is requested to kindly attend that. As the present chief minister is the cooperation minister at that time, my lord. Thereafter, a legal opinion is sought, my lord, page 80. There also, my lord, the standing council cooperation department, he has given an opinion since the contempt case is filed on so and so, you are authority for the payment, outstanding salary of the petitioners so and so, and filed a review petition by so and so, outstanding salary, rather it will be compliance of the court orders earlier passed in their case. This is informed accordingly. My lord, I'm coming, whether your lordship is, my lord, whether they are entitled to or not. Since, my lord, I have filed an additional affidavit because in other cases the documents were filed regarding, my lord, inscriptions, and the date of inscription. Additional affidavit I have filed. Answer Bilana. Could you believe that? Reason? An additional affidavit was filed, actually, several additional affidavit was filed. Here, my lord, if you will kindly see, my lord, filed on 12 November 21. Annexure 1, my lord, is 8. That, my lord, is written from the by the Register of Cooperative Societies to the Chairman Assam State Cooperative Union. Dated Shillong, my lord, 14th of December 1961. In the last annual meeting, last annual ministers cooperation as well as on the registers conference held on 29 October to last November 1916 in New Delhi, considered the report of the study team on cooperative training and education. The conference entirely recommended that the administrative of all the junior cooperative training centers should run through special committees appointed with the approval of the state governments, and their accounts should be kept separate from the accounts of the other activities of the union. It had to that the Assam Cooperative Training Institute at Joyshagar was imparting training to the officers as well as to the non-officials under the direct central of the government through the principal of the institute. In the third 5 years plan, so and so, something. However, implementation. Yes. In order to implement the above decision and in order to make the movement a popular movement, the state government is considering the desirability of entrusting cooperative training and education to the state union. Accordingly, it is being considered that the Assam State Cooperative Union may take over the management of the training institute from the direct control of the state government with effect from 1st April 1962. The necessary steps may kindly be taken accordingly so that the policy decision may implemented as stipulated. The amount provided for the institute will be cancelled through the union as granting it for expenditure under the following heads: pay, DNS allowances, traveling allowances, etc. of all the state of the training institute, stipend and traveling allowances of training contingency. The union may retain the present staff of the institute to work under the union or deputation from the government service. If their service are required, but the staff shall be then under the direct and full control of the union. Next, item that here also regarding pay scale of the State Cooperative Union and Joysagar Training Institute. Here, my lord, I'm reading from the my lord. Last paragraph of page in my lord, that for the last of LD assistant, the scale of now given to does not conform to any approved scale, as it is not possible to reduce the scale of these persons who were already on employment. These existing incumbents may continue in the same scale, but all future appointments should be made according to government approval scale for district officer for such post. The present incumbents, the grade 4 also may be allowed to continue in the respective present scales, but all future appointments should be made in the government approved scales. The union should also abandon the practice of granting honorarium. Besides getting scales, it should also be stated that the qualification necessary for such scales in the respective posts are also listed upon. It is also observed that there is no effective control of expenditure. Some control is therefore considered necessary either from the department on by some procedural system or till such system is evolved, which can be done in consultation with Director of Account. You may consider if a senior government officer now on deputation to the union may be entrusted with the works of expenditure control within the organization. The CEO was deputed from the government. An ACS officer, he was controlling the union. Next page, sanction of additional fund and payment of so the staff function. It is written in 1975. The expenditure is debitable to the head of so state plan and non-plan scheme so cooperative union, general plan of so and corporation, all other plan and non-plan schemes subsidy to Assam State Cooperative Union, general non-plan so. The officially mentioned. Here I have the budget provision, other thing, my lord, I have enclosed here, my lord. Against their name, my lord, 16 statements showing details, pay and allowances of field staff for the year so and so, so and so. So my lord, budget was, my lord, placed and it was, my lord, approved accordingly of all the year, my lord. But my lord, they were getting the salary regularly, but since 2017, my lord, it is stopped almost. And other states, my lord, West Bengal, Telangana, and other many other states, they are getting the scales, my lord. I have already given, my lord, to my lord that written argument. Your lordship might have copied my lord.
We'll take note of the arguments. Yes. Anything else?
Yes, my lord, there is an affidavit showing, I have enclosed, my lord, that the other states getting scales, my lord. And other state, the cooperative union, they are getting scales, my lord.
That can be a ground of parity in this state also. That other states are doing it, so do it here also. Can that be a plea of
No, my lord,
priority.
It is, my lord, it is not that, my lord, in all India basis. Others, we are also getting, my lord. Earlier, we were also getting. I have read this, my lord, that for state of Assam.
Yes.
These letters were in the state of Assam, that, my lord, they have specifically stated, my lord, listen. And the judgment, my lord, coming to the judgment, my lord, now. Judgment, my lord, is far, because when the, my lord, cooperative department has, my lord, written to the finance. And, my lord, it was duly approved by all concerned, including commissioner, principal secretary, and the minister concerned. Thereafter, my lord, refusing by the, my lord, finance department to pay. That is the main question has to be decided. Because, my lord, the judgment, division bench also, my lord, earlier judgments were not written and their appeal were dismissed. That is at page 155. Now the judgment clubbed together with some of the cases which are not, my lord, factually not similar, my lord. Judgment is, my lord, at page 170 is the 11th portion, my lord, para 2 I'm reading. It is projected that the Assam State Cooperative Union, ASCU for short, was conceived, set up and established by the government of Assam for the promotion of cooperative education, training, publicity and propaganda work throughout the state of Assam. This said, ASCU was entrusted with the Assam State Cooperative Training Institute at Jaisagar, Mansonso, providing that a provision of rupees 5 lakhs as market for third 5-year plan with an annual phasing of rupees so. And the amount of the institute was to be provided to ASCU in guaranteeing it for the following expenditure terms. From various documents annexed to these writ petitions, it is projected that Cooperation Department of the State of Assam had dictated the terms and conditions of service, and that had order number so and so had directed the register of cooperative societies to the effect that if in future it was intended to replace the deputationist by their own persons, then it will prescribe any scales for such post in consultation with the department and in conformity with the approved scales of the government for such post. Accordingly, from time to time, whereas amounts for sanction for payment of salary, payment of area pay, DA and DR in revised scale to the staff of ASCU, including the departmental officers on deputation, further providing that the expenditures were debitable to the heads of accounts as mentioned in various occasions. So now that cannot go back, my lord, with their own rule. It is further projected that from time to time salary allowances, DRS allowance and allowance relief were approved by the Cooperation Department and that the requisite funds were sanctioned by the Finance Department after budgetary allocation. Accordingly, it is also projected that till so and so the government of Assam was providing funds through proper budgetary allocation of ASCU entirely for payment of salaries and other emoluments, retirement benefits, etc., as per the prevailing scale at par with other state government employees. Thereafter, the state government had started to cut down the grants in aid to the ASCU, which reshuffle in non-payment of salary, accumulation and area salaries payable to the employees of the ASCU. By contrast, the stand of the said respondents is that the management of cooperative training and education was given to ASCU with effect from 1/4/1962. Later on, the state government had enacted the Assam Rajiv Gandhi University of Cooperative Management Act 2010, and accordingly, the functioning of the Assam State Cooperative College at Jaisagar was handed over to the Assam Rajiv Gandhi University of Cooperative Department. Thus, the other employees of ASCU not associated with the work of cooperative training continued to remain as employees of the ASCU, and as such, it is rejected that all the petitioners in this petition, being the employees of the society, not maintain their petition against the state. It is projected that the state was not liable to pay the salary emoluments, etc., to the petitioners. For such a long period, my lord, they are serving. In case of, my lord, amalgamation with another departments or college, university, whatever, they should have also been absorbed It is the minimum
That is not
principle.
the subject matter of this appeal, madam.
This is not, my lord, but it is a question of, my lord, that if they, my lord, separate, they cannot, my lord, after serving so many years, they cannot say, oh, bye, you go, we are,
Serving whom?
another,
Is there a deep and pervasive control of the state on the affairs of the cooperative society? No, absolutely no. They have their own setup. They have to manage their affairs. They're not able to do it. Can't help it.
cooperative union is a state created department, my lord. Whatever it is, not department, it's an union statutory body. And my lord, it is created by the state. So since they are, my lord, imparting education in cooperation department, they cannot, they have paid for so long time. Now they cannot say, state cannot deny that we are making an university.
That was all a grant in aid, nothing beyond that. So grant in aid cannot form a precedent. Read the judgment, please. Come to para 12. Come to para 12.
Yes, ma'am.
Yes.
Having heard the submission made by the land council on all sides, the various pleadings on record to ensure representations.
And rather you come, madam, come to para
Point of
19.
determination.
Para 20.
Yes, ma'am.
Para 20. Come to para.
I was to read about. On the, out of the above referred four criteria in the present case in hand, the petitioners have been able to satisfy this court that the ASCO was receiving financial aid from the government. However, in the absence of any materials on record, this court is unable to hold how ASCO was formed and what was its shareholding pattern. What are the aims, objects of function ASCO, and there is nothing on record to suggest that at present the management and control of ASCO is with the government functionaries. That is, my lord, that already I have submitted, my lord.
Maybe at one point of time it might have been, but control, maybe placing one or two officers doesn't mean that the control has been rested. Control was never rested. The deep and continued, deep and pervasive control of the government. That is the test.
Normally statutory bodies, they are also
Statutory body.
controlled
There's-
by the own manner bodies.
There's a Rajasthan State Road Transport Corporation,
Yes,
which runs all road transport buses in the state. It is not a state government undertaking. It has to pay its employees. It has to garner its own funds. Municipal bodies for that matter. They are not under the pervasive control of the state government. They are autonomous institutions. So
But my lord, they are
same
not a
way.
commercial organization to earn anything, my lord. It is not a commercial organization, still it is, my lord, earning, they are imparting education and training, my lord.
Yes.
Here, my lord, some-
Read para 20,
That
madam.
para- yes, my
20.
lord. Yet there is one factor which deals in favor of discarding the son of the state, that ASCO is not the instrumentality of state, which appears to be wholly unacceptable. Because by virtue of the provisions of section 25 of Assam Cooperative Society Act 2007, money as envisaged therein statutorily come into the coffers of the ASCO. Thus, the existence of ASCO has its source in the Assam Cooperative Societies 2007. So, my lord, Nana Judge has correctly discarding the then by the
Please
state
keep
that
on
ASCO
reading.
is not the instrumentality of the state.
Yes.
Yes. The factors which still in favor of ASCO to be held to be an authority under Article 12 of the Constitution of India are the financial assistance of the state meets also the entire expenditure of ASCO, which indicates that ASCO is imbricated with governmental character. From the provisions of section 25 of the Assam Cooperative Societies Act 2007, it appears that the ASCO enjoys monopoly status, which the state had statutorily conferred and protected. There
Come
is
to
no
para
denying-
25. So all right, you are permitted to bring a writ against ASCU. All right. To that extent, your remedy is permissible. Come to para 25. What is the liability of the state?
Similar, yes, madam. Similar issue was examined by the Constitution Bench of Supreme Court, mentioned subject team, order, and recommendation, so, wherein while deciding that Oil and Natural Gas Commission, Industrial Finance Corporation, and Life Insurance Corporation of India were authority within the meaning of Article 12 of the Constitution of India, it was held that their employees did not become the servants of the union or the state. That's true, my lord. Therefore, this court is unable to accept that the petitioners are government servants, but the petitioners would remain to be the employees of ASCO. There, one thing is, my lord, the government created a body which has no earning source, my lord. So how can they pay, my lord? Because government is funding, otherwise it will
That's
get.
all right. Grants in aid are received. So
Yes.
you have to carry on with the grant in aid, whatever is received.
I looked at all the government rules and terms and conditions. This, that. Some. Enjoy her this. Now I'm reading from my written argument, my lord. Mostly, my lord.
You don't want to
From the
explain the
my lord,
findings of the learned single judge. You're not desirous of coming out with any arguments regarding the findings of the learned single judge.
No, my lord, I'm coming. Here, my lord, the judgment, there is a factual mistake also, my lord. May I point out this, my lord?
Yeah, definitely. It's your case. चला देना जाके.
Paragraph 36, my lord. That from the order to the so pass in W so and so, as quoted here before, it is crystal clear that the last paragraph thereof to the effect that after hearing that there are no materials on record to show that ASCO had adopted all the government rules and regulations and terms and conditions of appointment. Thus, the petitioners cannot be treated at par as the state government employee, thus there being no contact. So, the state cannot be directed to pay the salary and emoluments to the petitioners. Thus, in other words, the petitioners would have the terms and conditions of employee of so available to them and payment of regular salaries so so paid to the petitioners. It is my lord quoted, but actually when the judgment, earlier judgment 2005 case, that is not, this portion is not there, my lord. Maybe the
Maybe.
stenographer has done
Some
some-
other judgment.
Yes, my lord.
So you have to file a review. Then you are required to file a clarification application. Then you'll
That
see.
is-
Yes.
Thereafter, my lord, regarding the finance.
Mm.
I'm pressing from my written argument, page 7, my lord, that this thing is within, because the Nanak Single Judge has relied on, my lord, that Kamul case.
There is one judgment of Riteshwar
Ritesh.
Niyog.
Moreover, there is no legal law holding that ASCO is a government instrument under censorship. Distinguish between state of Assam and Barak. The following points, the above mentioned cases can be distinguished as below. Because he has relied on that case, my lord, Supreme Court case, and my lord, he has stated that is par incuriam. ASCO and my lord Kamul. ASCO was formed with the sole intention of imparting cooperative training to the farmers, weavers, fishermen, and many sectors to earn their livelihood by constituting cooperative societies and the benefit of cooperation among themselves. Whereas the Kamul was formed and registered to run cattle development projects as well as milk processing infrastructure under a centrally sponsored scheme between 1981 to 86. ASCO is imparting education purely selflessly and as a social responsibility as guided by the Registered Cooperative Society Assam. No fees are claimed for educating the farmers and all costs as well as expenses are received as government guaranteed. Whereas my lord, the earmark amount of release on 50-50 basis by the central and the state government with 70% loan component and 30% GAN component, although the loan was not repaid by state government, provided for 43.6 lakhs for developing the milk processing infrastructure. This is a really commercial organization. ASCO is a non-profit and non-business organization. All the share capital of the cooperative is subscribed by the government of Assam. No individual private person has any share or any interest in the union. Whether Kamul was formed under Operation to Operation Food to increase production of milk in Barak Valley in Assam. And the finance of the cooperative union is entirely met by the state, that is the state, that is the government of Assam Cooperative Union. The Kamul had a mandate to create branch cooperative societies to increase the collection of milk and set up processing plant and earn profits by selling milk. ASCO enjoys monopoly status by doing public service, training, research and evaluation, education which is free of cost and have no business to venture to earn money. ASCO is an educational institution only. Whereas Kamul was authorized to carry out commercial activities, government had provided grant and other financial support for setting up of the commercial activities. Kamul is a business organization. The functions of the union are of public importance and closely related to government function and the social obligation to the society. Whereas purpose was to increase production of milk by commercial activity. The ASCO was formed under the instruction of Government of India by the state government. It was formed by the state government with initial handholding and then run commercially on its own like Amul, Amul, Puruvidari, etc. Thus, from the above, it can be fairly concluded that the ASCO in the present case is an authority fallen within the definition of Article 12 of the Constitution of India. The Nana Single Judge has quoted a paragraph from the judgment even already quoted. So in Korean, the learned judge has holding it, my lord, that this case was decided, my lord. Kamul case was decided by the Honorable Supreme Court, so much it falls. But what it is the basic structure is not different of both the societies. Union, my lord, is not formed by government and the instruction of the Government of India. And my lord, that is function is completely different. It is a social law.
Yes.
But my lord, the Kamul, it is formed, my lord, for a commercial activity. Milk will be, my lord, selling of milk will be increased and it will be make systematized. So finance have not filed any affidavit, no? They filed question,
Yes.
they have not filed any affidavit. But the main thing is, my lord, that once upon, my lord, that cooperative department has nothing to do, my lord, but the finance, if they don't sanction the amount, either it is, my lord, granting aid or the salary as per, my lord, direction of this honorable court, my lord, their petitioners are helpless, my lord.
Okay.
And there are authorities, I don't know the place, my lord, because
Yes. That's all.
regarding in Korean. Yes, my lord.
Very good. Yes.
May place a lot. Lordship, right from day one, the government has been providing granting aid to the petitioners society. First of all, they are employees of the society. They are not government employees, your lordship. They have their own bylaws. And in fact, in the bylaws, there is in clause 7, they have clearly stated that where from they can
generate the
funds, your lordship.
Okay.
So if your lordship can kindly
Let's see.
have a- Yes, okay. Okay, that's it.
Yes. Which is the bylaw you're referring to?
Number 7, your lordship.
Convene and hold seminars.
Lordship.
So that is a subclause. of-
And that is fund.
Fund, your lordship. It is
Yes.
fund.
Yes. The various heads are there.
Yes, your lordship. Now they can generate funds from annual subscriptions of the members under section 5 of the bylaws, granting aids from the government. It is the second point. Thirdly, educational funds created out of cooperative development fund
Fourth is donation and contribution from the cooperative institution organization. Fifth is contribution from profit of the member society. Sixth is sale production of publication, periodicals, textbooks, films, etc. Then seventh is loan and advances. Eighth is income from exhibition, projects, activities undertaken by the union.
Yes.
Now they can generate their own fund, your lordship. And right from day one till date, your lordship, they have been provided granting aid, and it is the society who has utilized that fund to release the salary of the petitioners. your lordship.
Okay. So you mean to say state has no
State
liability?
has no liability, your lordship, and the policy.
And you are continuing the granting aid or not?
No, your lordship.
Why? Why was that discontinued?
As per my instruction, your lordship, a policy decision has been taken by the government.
Which is that decision?
Lordship. Rajiv Gandhi, your lordship. It has been reflected in the single judge judgment, your lordship.
Have you placed that decision on record? That particular decision or resolution or notification
That has
is it
not
on
been-
record?
That has not been placed, your lordship.
Judgment
130.
134. What is said? Let's see. Hmm. Yes. Hmm. All right, you have established a university for the purpose of cooperative movement. So, well, what about the employees who are already there? From where? Okay. Still getting. All right. Okay. Yes. Okay. Very well. Anything else to say? That's all. You want to say, Ms. Nayak? Yes, yes. Yes.
Accordingly, in my submission, what has made no submission in I feel
That we asked madam, but she's all right.
so for earlier petitions are concerned,
Hmm.
in those petitions were not for payment of salary. Those
Release of grant in aid,
those petitions were by paying for regular pay,
regular pay scale, yes.
not for non-payment of
Yes, yes.
issues are different.
They've sought any relief against the ASU? No. Probably not. What is the relief against the ASU which you have sought? You yourself said, madam, that you have not sought any relief against the union. That's right. Where is your relief clause of the writ petition, please?
In the writ petition, my lord.
Yes. 43, let us see. Equal pay for equal work. No direction against the.
Respondents to pay the salary regularly as well as the area salary to the petitioners as sanctioned by Iman so and so, issued by the Joint Secretary so and so.
All right, okay.
Area salary and salary. The finance
What do you
department
say?
has filed an affidavit, my lord. The finance department filed an affidavit. That
Yes.
is in page 138, my lord.
Yes, what does the department say?
139, your lordship, my guy.
Yes,
139.
yes.
That the deponent begs to state that the role of Assam State Cooperative Union was for implementation of education, training, publicity for the development of cooperative women for state with the establishment of Assam Rajiv Gandhi University of Cooperation Management so and so, and the role of capacity development, education and training
Yes.
has been fully entrusted to our
That
government.
we have
Therefore,
read.
policy
There was a
decision-
one-time arrangement to grant some aid to the union, that's all.
Yeah,
Okay.
my lord, they have not enclosed the policy, so we don't know about this. my
Very
lord.
well, okay.
And my case is, my lord, that if the cooperative department has also, my lord, sanctioned the amount, so it should be paid, my lord. And my lord, the guarantee aid should be given because as my learned friend has placed, my lord, regarding fund. Grant and aid is there, so grant and aid should be, my lord, given regularly. to the
It
my lord.
can be issued to the government that yes, you have to pay the grantee rate. That's the discretion of the government taken on policy matters. Very well. All right.
Grant in aid money.
Arguments heard, judgment reserved.
Item number 5.
Yes, please.
Made to the one. But this is an appeal preferred by the state, my lord, against the judgment dated, my lord,
Yes,
22/1/2019, my lord.
yes.
The respondent, my lord, filed a petition claiming for salary, my lord.
Yes.
Basically, she was against the non-payment of salary. Her case is that she was appointed in the year 1999 and she received salary till 2006. Thereafter, my lord, her salary was stopped.
Yes.
So then she filed writ petitions in the year 2000. First writ petition was filed in the year 2008, my lord.
Yes.
2007, my lord. That writ petition was disposed of directing to place the case of the prisoner before a committee, my lord, expert committee constituted
Yes.
for determination of payment of salary, my lord.
Oh.
That was placed, but could not be considered because the original record of appointment was seized by the deputy commissioner in a particular for a particular district, my lord.
Yes.
So subsequently, she again filed a petition that was again disposed of in the same direction, my lord. Later on, 2015, my lord, she again approached this honorable court, and this honorable court was pleased to pass an order, the impugn order here, my lord, to pay the salary if she was working.
She was working, yes.
Without deciding the issue of legality of her appointment, my lord. In our affidavit, it was our categorical stand that her appointment was illegal.
Illegal, okay.
So that was not considered, and direction was.
You want to
pay the
remand?
salary. Sorry, my lord.
Do you want to remand on that issue?
Yes, my lord.
Let's see where, what is your affidavit
Yes, my lord.
in your, the affidavit in the writ petition?
Page 72, my lord. Page 72, first amendment made in the paragraph 4, my lord.
72.
My lord, may kindly come to page 73,
Mm.
paragraph 4. May I read, my lord?
Yes.
That by way of the instant writ petition, the petitioner is praying for a direction to the respondent authorities to release her arrear and current salary from May 2006. The petitioner contends that pursuant to a selection process initiated in the year, she was duly selected and appointed as an
Yes.
assistant teacher and posted at 143 Boroma Nimno Bunyadi Vidyalaya under BT, while order dated 4/12/1999. As per approval of the Subdivisional Elementary Education Advisory Board, Nalbari, Borodan Autonomous Council. However, this is our category stand, my lord. However, she was not annexed any document showing her participation in any selection process pursuant to which she was appointed, such as advertisement, call letter for interview, duly approved select list showing her merit list to substantiate her claim that she was validly selected and appointed.
Right.
So, my lord,
Any affidavit in reply?
no, my lord.
In
In
this,
that,
yes, it is there, no? It's there, let us see. It's at page 88.
yes, my lord.
Who paid the salary up to 2006? By what means was she paid the salary?
From state fund.
What is the reason then?
Then, my lord, in fact, my lord, during the year 1989 to 2001, in entire state,
There were
there were
illegal.
illegal appointment, my lord. It is an
Where is
appeal-
the appointment order?
Sorry, my lord.
Where is the appointment order which?
Appointment order at, my lord, page 53. Page 53, my lord. This is the
Deputy
appointment order
Inspector of Schools.
by the Deputy Inspector of Schools, my lord.
He was the appointing authority under what rules?
In earlier, my lord, he was the appointment.
He was the appointing authority.
Yes, my lord, earlier. But now, my lord, Director of Elementary Education is the appointment authority. So, here, my lord, our specific case is that, my lord, during the years.
In the appointment order, if you say that Deputy Inspector Schools was authorized to make the appointment. He says against a sanction post
Yes.
and you have been paying salary from 99 to 2006.
2006, my lord.
Yes. Then,
In 2006, when it was detected that her appointment was
so any
illegal.
order whereby your appointment was caused, questioned,
Yes, in fact-
withdrawn,
In fact, we have issued a show cause notice.
where is that?
This page 57, my lord, show cause notice. It reveals that you were shown, you were shown appointed a teacher in a provincial's lower upper primary school. There are no records to show that you were selected as per rules for appointment as a teacher, as
Okay.
provided by the Assam Elementary Education so and so rules.
Hmm.
Hence, it appears that your appointment was made in violation of the said rules.
What happened thereafter?
Thereafter, my lord, page 58,
Hmm.
she submitted
The documents.
documents, my lord.
All right, then,
There's nothing has happened, my lord. We stopped the salary.
then that is acquiescence.
We
You
have-
gave her a notice, you never carried it through.
Yes, my lord,
Then?
that is there, my lord. But, my lord, pursuant to the order of this honorable court, we have constituted a committee, my lord, screening committee we have constituted to identify those illegal and irregular appointee.
What has been done there?
Thereafter, my lord, she participated in the said selection, this screening process, my lord.
Hmm.
And it was found that her appointment was illegal. It was a fact-finding committee, my lord.
Where is that
It was-
report?
In fact, we have even pursuant to that, my lord, a cabinet decision was taken. And in that cabinet decision, it has been decided to accommodate those illegal appointee as a teacher or tutor as per their present qualification.
Hmm.
And we have given her fresh appointment also, my lord.
That she challenged in this.
No, my lord,
Then-
she has not challenged, my lord.
That is not under challenge.
That is not under challenge, my lord.
Mr.
That appointment order is page 124.
Page
124, my lord.
124.
That is the fresh appointment order issued on 30th January to 2021.
Hmm. On a fixed salary of 10,000.
10,000, because
And past services cannot be claimed.
the cabinet decision,
Past services, salary for past services cannot be claimed. That is in violation of the High Court order.
High Court order was issued to if she was working to pay the salary, my lord. And while we have
But you have not come out with a case that she was not working.
no, my lord.
It's
In
not
fact,
your
we
case.
in fact, in this proceeding also, pursuant to the order of this honorable one, we have filed an affidavit.
5 lakh rupees you have paid
Yes, we have paid.
towards
also.
her services.
Yes, my lord, we have paid.
Then
In fact, this is the cabinet decision taken.
place it
accommodate-
on record, they will have to right to challenge that decision.
Yes, my lord, but they have not challenged it, my lord.
That's not on record.
My lord, in fact, we have issued the appointment order, my lord. Appointment order is there, my lord.
Last time this issue came up, my lord, your lordship said you'll have to file objection. So we have filed an objection. Because this tutorial appointment, your lordship will say, see, this is on the face of it in violation of the High Court's order. And it says you will get 10,000 rupees salary and the appointment is will be valid for a period of 15 days.
15
That is-
days.
15 days or so, my lord. Your lordship will kindly say that the order, I have typed it out. What is it?
Just hold on, hold on.
Page, your lordship will kindly see page 182.
Just
182.
let's see the original order first. Page number 124.
124, your lordship will not be able to read it.
No, we will be able to read it. Don't worry. Yes. No, appointee will have to join in his/her place of posting within a period of 15 days from the date of issuance.
Yes.
So that's the joining time.
Yeah, then when it says that you cannot claim any salary,
Hmm.
one will have to join so and so, the appointed will
Yeah,
get
what is this?
prospective effect
They have
from
filed an objection
1/11/20.
against
and
this.
But they have not challenged this appointment order.
In that objection, they have done it.
First appointment letter has not been dismissed, but not been cancelled.
How come this appointment order could have been issued? You took steps.
Yes.
You issued her a notice, show cause notice, then you slept tight over it.
During that time, my lord, it is admitted that nothing was done. But
No.
in 2010.
It's totally illegal. We'll quash it right here.
In 2010, my lord, this process of screening was started, my lord.
What you did
And
thereafter,
ultimately, it was ended in the year 2018. And the cabinet took decision in the year 2020, my lord.
that cabinet decision is not on record. This order is nothing. It's a waste, rough piece of paper. That's all. In service candidate, how can you say that now we place you at a temporary level? She's an in-service candidate as per her.
But-
Because you did not act after your show cause notice, you kept sleeping tight over it.
That is there, ma'am, that is.
So that is there, then there is no way out.
But my lord, in fact, my lord, she is not the only candidate. But there are so
Maybe-
many candidates, my lord. In fact,
Maybe
In.
the others might not have come to the court.
There are
275 students were, teachers were appointed and their salaries were stopped. There, all others are working. I have given my lord in affidavit reply.
They are working.
They are all
on the
working,
previous-
they are getting salaries.
There are
I've stated
different categories of
categorically in my affidavit reply.
cabinet find out, my
Mr.
lord.
Katniar,
Kindly see
you issued her a notice questioning her appointment order.
Yes, my lord.
You say that the appointing authority was competent. If the process was wrong, where is your finding? In pursuant to that show cause notice. There's no finding.
Yes, my lord.
Even
That
in
finding-
this fresh appointment order, what does it say? Whether her appointment was illegal? Let's read. What does it say to her regarding her previous appointment?
Nothing, my lord.
Nothing. Then this order is a farce.
And contempt, your lordship, will kindly see page 185, contempt order has been issued.
Contempt notice.
Contempt notice, my lord, detailed order has been issued for page 186.
Yes. 186, no,
Yes, ma'am.
it's not
It is
186.
an order issued in contempt saying whether the petitioner was appointed as a teacher by the order dated 99 issued by the director of board and was transferred subsequently to another district which does not come under the BPC. After her appointment, she was paid the monthly salary from the date of her appointment.
Hmm.
However, payment of her salary stopped thereafter being agreed by WPC and after the matter
Yes,
was
yes.
heard, my lord. So this is the matter. Your lordship has also, my lord, passed an order, my lord, judgment. And if they are working, my lord, you cannot deny your salary. And I'm also, my lord, Supreme Court judgment are also there from page 188 to page 199. I have annexed paragraph 27, I think, my lord. And page 188 to page 199, my lord, I have annexed 4 judgments of the Supreme Court and the High Courts. Saying that, my lord, you cannot extract the work from an employee
Yes.
without paying any salary.
Katniar, this order is nothing. You never cancelled her past services. You never withdrew that order. Sorry.
But the honorable single judge, my lord, while dealing with the matter, my lord, doesn't consider this respectable matter that her appointment, in fact, legality of the appointment was not considered, my lord.
That is not required to be gone into by your own conduct.
Only observation.
Once you give a notice questioning her appointment and then don't take any decision. Even in your fresh appointment order, you don't make a reference what is nature of her past services. Why are we supposed to adjudicate on that? Nothing. An order of 1999.
Yes, my lord.
Nothing.
But as regards, my lord,
Review was dismissed with cost of rupees 50,000. They filed review at 129, it a cost of 150,000.
Have they paid or not?
no,
They have
that
not paid.
stayed, my lord, that order,
That order.
the
was
order,
Now that will be revived now.
my lord, in fact, kindly come to the review order, my lord.
Yes. Read.
Page
Yes, ma'am.
129.
Read, please.
It's in the read
Yes.
FL, my lord. Page, last page, my lord.
Yes.
In view of the above aforesaid facts and circumstances, this court is of the view that no ground for review has been made out and the same is accordingly dismissed. Since the bona fide of the review applicant is itself questionable, this court process to impose cost of 50,000 only upon the applicants which is to be deposited so and so. Malad, we have filed the review saying that the petitioner participated in a screening process which has not been projected
What
before the
kind
honorable
of
single judge.
screening process was it? For what purpose?
The screening
What was the
process-
purpose of screening process?
This screening process was
To find out whether she was a regular appointee,
Exactly, madam.
illegal. Where is the finding of that screening process?
Malad, this is the decision of the cabinet, madam. In fact,
Mr. Katniar, there has to be a specific decision by each candidate. Where is that decision?
my lord, we have, in fact, I have annexed the list now here. my lord. Yes, my lord, I'll come to it.
What is the reasoning?
123, my lord.
What is the reasoning?
Page 123.
What is the reasoning, please?
In the list, there is no reasoning, my lord. That reasoning, my lord, kindly appreciate one thing, my lord.
No. we are
This
not
is,
allowing you to- Yes.
this screening process is not only for the petitioner, my lord.
We
It's
are
for the
not bothered.
12,000
So if you
employees.
take a finding on this matter, your entire decision will go.
My lord, this screening process
Take that
was
risk.
conducted, well, kindly let me submit on more. This screening process conducted for 12,000, my lord. And we have prepared a list according to the document, verified document, my lord.
You have to
Whether they
give,
have the,
Mr. Katniar, this is a rule of law.
yes, my lord.
Whether you can just by stroke of pen say, this is illegal, this is legal, this is irregular, this is regular.
No, my lord, verification.
Where are the reasons?
Verification was done, my lord. The region, my lord, in fact, if my lord permits me, sometime I can produce the regions, my lord. How they have conducted the screening process, my lord. That I can produce, my lord.
All right, Ms. Das,
There is-
let him produce.
That is all right, my lord. What they have done, we do not know. They have pursuant to the screening process, they should have given a notice to us.
Yes, notice has
should
to be
have-
given
they should
that
have
your
cancelled
services
our
were
appointment.
irregular. We have proposed to cancel it. Where is
Yes,
that
my lord.
notice?
There was a decision to, in fact, in this cabinet decision, my lord, there was a decision to terminate them.
Cabinet-
Subsequently, my lord,
You should have done that. You should have done that.
subsequently the.
So termination would be a person who is in service
No, my lord, that termination was never executed, never
for
executed.
good reason, because moment you issued it, you recognize her appointment.
Then, my lord.
You give
cabinet-
credit to that. Yes.
Took a decision to accommodate them freshly, my lord. And this,
There's no order in the eyes of law.
my lord,
That this judgment will have an impact on your entire policy.
that is why, my lord, give me some time so that I can produce the,
After arguing the matter for some time.
I'll
Mr.
produce
Katniar,
the,
place for short opportunity to place on record the reasons behind issuance of the order dated. Before that, you take Ms. Katniar, during the course of arguments, has drawn the court's attention to the order dated
124, my lord, please.
thirtieth January 21, whereby, the petitioner, respondent here has been appointed afresh as a tutor in the accommodated, not even appointed, accommodated as a tutor in the LP/UP school on purely temporary basis in the fixed salary at the rate of rupees 10,800 per month.
And she-
However,
And she will not be able to claim any salary for the past services.
the order further recites that the respondent shall not be entitled to claim the salary for the
Past services.
past services. Mr. Das
That-
and senior counsel pointed out that this order is in gross contempt to the orders passed by this court in the earlier rounds of litigation. This court is also apprised of the fact that
All similar-
earlier, the respondent herein was issued a notice. Where is that notice? Ms.
Yes,
Katniar,
57, my lord.
57.
Yes, my lord. The earlier show cause notice,
Yes, show cause notice dated
17th October, 2006.
17th October 2006, requiring her to show cause as to why her selection as a teacher in the provincialized lower/upper primary school should not be cancelled, as the same appeared to have been made in violation of the rules. However, it is not in dispute that the notice did not result into any considered decision cancelling the selection of the respondent. She continued to serve as a teacher till the year 2021, when the order referred to Supra came to be passed.
Even now she is serving.
Mr. Das points out that even as on date, the respondent is serving in
In same school.
the same school where she was appointed.
And persons who were appointed along with her, they are getting salaries. Stated in
This
the
court is further informed that other similarly situated candidates are being paid regular salary by the state authorities. Full stop. We further find from a perusal of the order dated 30th January 21 that it does not reflect to the fate of the earlier appointment order of the respondent. Thus, prima facie, without the said appointment order dated so and so having been reversed/recalled/ rescinded, comma, the fresh, the fresh appointment in the nature of a tutor on fixed salary basis is by itself questionable. Appointment order dated 4/12/99. Faced with this situation, comma, Mr. Katniar prays for short opportunity to place on record the cabinet decision / minutes of the screening committee in which the case of the respondent was considered. Or सिर्फ minutes ही लिखिए. Minutes of the screening committee in which the case of the respondent was considered. Re-notify on 18th October.
18th October.
Obliged, Lordship.
The only question, my lord, according to me, if she is serving, she should be paid salary. This is
That
what the
they have
law-
admitted, that they are admitted already.
No, in contempt proceeding, they said, my lord, submitted, the proposal has been sent.
Yes.
So therefore, my lord, learned single judge, division bench, my lord, directed you pay 5 lakhs. rupees.
That has been paid to her.
Fine.
Right.
Obliged, my lord.
Obliged, Lordship.
Item number 6 to 8.
May I please? All the three matters are analogous, my lord. Is against the judgment order dated 36/2022 passed. This is a common judgment order, my lord. And the petitioner basically agreed against the direction part.
Direction?
In the direction, the learned single judge has directed the authority to verify the, my lord, but what happened, the petitioner.
Give us a
executed
brief
particular
facts at
work,
least,
my lord.
yes.
Particular work under the railways. my lord. While executing the works, apart from the other materials, the ordinary art was used. my lord. Now the railway insisted for the royalty from the petitioner in respect of ordinary art. my lord. My contention for learned single judge was that just in the contract agreement, there is no my lord, my lord, there is no condition contained in the contract act which enable the authority to recover the royalty, my lord. Learned single judge while dealing with the
What was the writ petition? What were the writ petitions against?
my lord.
What were the writ petitions filed against? What was the relief sought in your writ petitions?
Writ petition petitioner is agreed against that or the royalty which was one of insisted by the petition that
Railways.
Railways.
Let us see the order. Where is the demand of royalty or the, where they asked for royalty?
Well, page 269, annexing of P6 mode.
269.
Well, petitioner is not, there is 5 items. They insisted for royalty against the 5 items. Petitioner is not agreeing against the 2, 3, 4, and 5 malay.
Okay.
Admittedly, those are mentioned in the contract agreement.
Contract.
Regarding artwork, or ordinary art, there is no agreement. That is the standard, that is the contention made by the.
No, there is no.
No condition contained in the contract. Who's enabling the respondent railway to recover the royalty, madam. While dealing with the, this batch of the petition in the common judgment order, learned single judge deal with the all aspect of the matter. And taking into view that 2003 to ELP page 945, the Muslim Ali versus State of Assam is a division bench order where it is clarified. If there is no condition contained in the contract agreement, the authority is not empowered to claim for that royalty. May I draw, place the judgment for your lordship.
This judgment copy you have given. It's here. It's available.
And in fact, my lord, after this particular imping judgment, there is another order passed by the learned single judge. Similar circumstances, my lord. This is the order where the learned single judge in another matter allow the
What is the name? What is the name of the parties?
Malot, Raitani.
Yes, we have a copy. If you have a copy. Yes. What do you say, Mr. Gogoi, Mr. Counsel? Different judgment, different views taken.
My lord, may kindly come to page 70 of the read.
Hmm.
Page 70 of the read.
Yes.
Page
70.
70, lordship.
Yes. Read.
My lord, may kindly come to 13.2. It's a condition of the contract, 13.2, lordship.
Hmm.
It says that, lordship, whenever forest produce like sand, stones, timbers, etc. are used in the work, the contractors will have to furnish documentary proof the requisite royalty on such produce has been paid to the concerned department. There is a condition is there, lordship.
The condition is there. All right.
This condition not stipulated to the ordinary earth, madam. Yeah, let us.
Ordinary earth means what is the difference in sand and ordinary earth?
Sand is not ordinary earth, madam.
Lordship may kindly peruse page
It should, my contention is for the learned single judge, it should be specifically mentioned.
Specifically mentioned. Okay.
It is not there, madam.
Then
Yes.
lordship, kindly come to page 269, lordship.
269.
269, lordship. This is the letter issued by the Railway Authority for submission of the forest royalty clearance certificate, lordship. It is not a demand by the railways, lordship. It's a
Okay.
forest royalty clearance certificate in respect of one is artwork, lordship.
Yes, yes.
And artwork part is my brother will clarify, lordship. The artwork is the within that ambit, lordship.
So the demand, as a matter of fact, would be raised by the forest department.
Forest department. And artwork is ordinary art is, lordship, within the minerals part. lordship. That my brother will.
Yes, Mr.
And
Gogoi.
judgment is also there, division bench, honorable division bench judgment. My brother will place it. lordship.
Let's as he has, my colleague has pointed out, my lord, this is not a demand for royalty. This is just you.
Forest.
You have consumed, show that you have brought it from a legal source.
Right.
Even that is the condition, madam. Even that also, my lord, I have placed on judgment. Similarly, at the
Which-
judgment.
which-
statement,
which- what is the
2017,
name?
my lord. It's 2017.
Durga Krishna.
No, my lord, it's in DH Vijapura. I've
Yes.
given the book number, my lord.
Yes, we have copy.
Yes.
2017, volume 3 GL.
Yes, my lord.
Yes.
The concluding paragraph, my lord. 21, 22, 23. Even if he, my lord, if somebody consumes from the extracts and consumes from private party also, he is liable for royalty. All the petitioner has to do, my lord, he has to show that he has bought it from a legal source. And that apart, my lord, S10 has been taken in the pleadings that he is not a lessee or mining holder. He relies upon section 9 of the MMDR, whereas my lord, section 15 says that section 15 says 13(9) is not applicable. It regards only to my lord, minor minerals. My lord, this judgment squarely covers my lord. And the judgment relied upon him, my learned senior, my lord. I was the counsel, my lord. That was the provision quoted that you have to submit only the source. If you have paid, you get the certificate. That's all.
FRCC stands for
Forest
royalty
clearance certificate, my lord.
clearance certificate.
I am not agree against the judgment, impeaching judgment,
Yes.
finding of the impeachment. I am only the direction part. In the judgment, it is purely to my case. My case is that since in affidavit also, the railway authority filed the affidavit, they are not able to show that there is any clause in the contract. So admittedly, in view of the division by judgment in Muslim only, that's the landmark judgment, in view of the Dutch judgment, they cannot claim for the FRCC.
They are asking that whatever you sourced for the work in question, that should be from a legal source.
Even lordship, in our affidavit also, our stand is this. My lord may kindly peruse page 272, lordship. Page 272, lord.
Yes. Read, please.
Paragraph 5, lordship, permit, I can read it.
Yes, yes.
Lordship. That with regard to the statement made in paragraph 6 of the writ petition, the deponent begs to stay as per the terms of the contract. The contractor is to supply laying of art in connection with the construction of railway embankment, guide, bunds, or any other work required for the railways in accordance with the RDSO guidelines and specification or specified condition in the contract, including all leads, royalty, leaves.
You can't just dig up sand from anywhere which you desire. That's not possible.
Even
You will have to satisfy the where from you procured it. That's what they are asking. That's fair enough. What's wrong? You can dig up the forest without paying royalty. That's what the meaning of this contract is.
Even paragraph
Tell
5
us.
is-
My contention will.
We'll
Will be of the learned single just finding, my lord.
Yes.
My lord, it is relied on the Muslim Ali judgment, the 2013.
Let's see let's see the ratio.
Given. There specifically says that if there is no condition stipulated in the contract.
So they are not
you cannot,
recovering. They are not
insist for
affecting,
efforts
Mr.
to-
Council, they are not affecting any recovery. They are saying that before we make payment of your bills, please satisfy us that you have procured the goods consumed, items used from a valid source. That's what they are asking.
Then,
Yes.
my lord, learned, the earlier judgment, it's contained that without any condition contained in the contract act.
Okay.
It
We
cannot
will,
be claimed for the forest royalty, my lord.
we'll consider that judgment as well. Anything else?
Can any contract be, my lord, contract be made in
Contravention to this statutory provision.
When rules is very specific, Lord. So rules
Yes.
is very-
contract cannot offer in the statute, there's a few statutes.
Very well. All right.
Oblige, Lord.
Arguments or judgment.
Oblige.
Hello.